that if anything inconsistent therewith contained in any other law shall have effect after implementation of the said Act 2013, the state authority has failed to appreciate the fact that the continuation of the earlier notification by virtue of WBPD's Maintenance and Control Order 2003, however, it inconsistent with the National Food Security Act. Moreover, as the state government has not specifically cancelled the vacancy notification dated 18/7/2021, in which the present petitioner was applied for, the respondent authority is duty bound to finalize the process of recruitment of the present petitioner by virtue of State Control Order 2003. However, the state authority may direct the petitioner to comply with the formalities as required under National Food Security Act 2013 or WPDS M&S Control Order 2013, as the case may be, for proper distribution of food grains in the locality. Subsequent notification or appointment in respect of the impugned site, if any, consequently treated to be cancelled. Thus, the instant writ petition appears to be meritorious and the same is allowed and disposed of under the above observation. Right. The state is directed to issue the appointment in favor of the present petitioner in respect of MR dealership at Ranivan under the notification dated 18/7/2012. If it appears that she fulfilled all criteria under the provisions of WPDS M&C Order 2003 and any other law for the time being in force, the respondent is directed to comply the order as early as possible, more preferably within 8 weeks from the date of communication of this order.
Hello. Deeply obliged, madam.
First item. এগুলো দেখা সম্ভব? এইসব ছেলেগুলো করবে প্রত্যেকবার ঝামেলাগুলো করছে, এরা এত বোকার মতো কাজ করে, আমি কি করবো? Yes. No? হবে This matter appears for correction. It appears that in the cause title of the judgment dated 4/7/2024, the name of the petitioner was not correctly mentioned. Accordingly, full stop. It appears from the cause title of the criminal revision that the name of the petitioner should be correctly read as, এটা দেখো একদম এই তিনটে নাম থাকবে একসঙ্গে, দুটো নাম করে ছেড়ে দিয়েছে, দেখেছো? ইয়নজিং পেং, এটা অ্যাড করে ইনভার্ট করা হয়েছে। The office is directed to make out the correction within a fortnight.
My lord, in this matter, there are 10 connected matter in this regard, which related to challenging the 2030 control order and related to vacancy. My lord, in this matter, there are item 2, 3, 4, and all the connected matter which is pending before lordship. My lord, I pray before lordship kindly pass over for the time being, my lord. My lord, no. Every day, my lord, my seniors is on the way, my lord. My lord, kindly for the moment, time, let it be passed over, my lord. You will take up.
Who is applying for the state?
State, my lord, Mr. Shishona Bandavada, in item, some of the item, my lord.
In which item?
Item 2, 3,
Hello, on the, in item 2, 3,
4, 5.
5 and 8, I am appearing for the petition.
Item,
On the last occasion, I filed the affidavit service, but passover was taken by Mr. Bandopathy.
Same thing.
Now, my lord, same thing is asked.
My lord, it will be, my lord, he's on the way, my lord. Just
item, your matter, item number?
2, 5, 8. 9,
2, 3, 4, 5, 8, 9, 10, 14, 15, 16, and 23. All are related to challenging the vacancy.
I think all mentioned matters are the same issue.
Same issue.
Give me the order,
Yes, my lord.
copy of order.
Yes, yes.
কোনটা দিচ্ছেন?
Kumkumar Rai. Last
প্রতি
order.
অর্ডার এটাও একটা
Same, same.
একই একই
ঠিক।
একই একই
কালকে আলীকে অর্ডার দিয়েছি, আলীকে দিয়েছি, আলী তোমাকে দিয়েছে? আচ্ছা, আলীকে দিয়েছিলাম, আলীকে ডিকটেশন দিয়ে দিয়েছি। একই থাকবে, মাঝখানে দুটো প্যারা শুরু করবো, একই থাকবে, মাঝখানে দুটো প্যারা শুরু করবো, ঠিক আছে? সেম সেম সেম। এই যে এখানে উকিলের নাম আছে, এই যে উকিলের নাম আছে, সেটা শুধু নাম্বার কিছু দিই, হ্যাঁ, এই নাম্বারটা একই সেম সেম, যা অর্ডারটা সব 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 এইখানে, এইখানে একটা ঢুকবে, একটা প্যারা বলেছি, এইখানে একটা প্যারা বলেছি, বুঝতে পারছো? বুঝতে পেরেছো? বলা আছে আলীকে, আলী কালকে আমাকে দেয়নি কারেকশন, ঠিক আছে? থাক, তোমাকে বলে দিচ্ছি। Yes, item number 2,
3.
item number 2, Mr. Agarwal is there.
My lord.
And who is item number 3?
I am for the petition.
4,
I am for the petition.
4, 5.
No, that's it.
I-
For 5, I am appearing for the petition.
5, Mr.
Ma'am.
Agarwal, you are there. And who is for the 6?
6.
6, same issue. 6 and 7, 6 and 7. 6, you are appearing. So let me call the matter one after another. Give me item number 2. This is item number 2. Affidavit of service already filed.
Already filed, my.
আরে রে বাবা, এবার তুই।
Affidavit by the state authority within 4 weeks from date, exception thereto, if any be filed within 2 weeks thereof, within 2 weeks thereafter. State authority is at liberty to proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued till the disposal of the batch of appeals pending before the learned division bench, being MAT 1543 of 2024 and others. Go out of the list, liberty to mention. This should be the order in all the cases.
Deep level.
May I- you-
My lord, there are. two
Item
more-
number 2, give me item number 3, one after another.
Three mallet affidavit service is there, mallet, in the file.
Okay. Let me see.
3, 4, up to 3 and 4, affidavit service is there in the file.
To file.
But I am for the petition.
Yes, affidavit service is there. Same direction. Call item number 4.
For I'm for the petition, FD service is there in the file, my lord.
For the state, my lord.
Yes.
Item number 1. Thank you.
Yeah, fine. Fine, yeah.
Same direction.
Okay.
Next.
I am appealing for the petition, my lord.
Come for the state, your lordship.
Affidavit service is already on record, my lord.
Let's see. Yes, it is there.
Section 2 affidavit service দিয়ে দাও না। একটা করে।
উকিল বাবুদের নামগুলো নিচ্ছ তো প্রত্যেক আইটেম দেখে দেখে নাও, বাকি যা আছে সব কি সেম ডাইরেকশন। নেক্সট।
Six, my lord, I am for the petition. This is the affidavit of service.
Who is for the state?
Six.
You are appearing for the state. Mr. Chatterjee, give me your name. Same direction. Next.
That's item 7. I am for the petition. Affidavit of service.
Same direction.
My lord, I have already filed the same.
Come for the state, your lordship.
Affidavit of service here. Who is appearing for the state?
I'm for the state.
You are for the state. Similar direction.
My lord, I am appealing for the petition.
For the state, my lord.
You are for the state.
All হাতের লেখা practice করছি।
Similar direction.
তাহলে এটাই দিয়ে দিচ্ছি।
But 10 to 13, I am for the petition. These are my 4 affidavits of service.
10 লিখে রেখেছি।
4 আছে পত্র সাজানো।
Who is for the state?
10. 10 এ কি আছে স্টেটে?
And I'm for the state.
You are for the state. Item number 10. Similar direction.
Madam, তুই আছিস?
Who is for the state? You are for the state.
ওই অ্যাপিল শেষ হলে তারপরে এখানে হবে।
Okay, similar direction.
12 pages. 12, but I am for the petition. I have handed over the affidavit service.
Affidavit of service.
12 তোরা আছিস? চিন্টু আছে 12? আরে চিন্টু 12 আছে? চিন্টু কততে আছে?
Who is appearing for the state?
I do not know. I have served.
This is item number 12.
12.
Affidavit of service filed on behalf of the petitioner is taken on record. First and take the whole. এরপরে লিখবে despite service, none appears on behalf of the state.
ওদের দোকানে
On behalf of the respondent. Respondent.
চিন্টু আসছে?
এই লাইনটা একটু ঢুকিয়ে দেবে। This is item number 12. ঠিক আছে? Similar direction.
And I am for the petitioner.
You are for the state.
ক্লিয়ার হতে হয়। একই জিনিস
It is a service.
ফাইনালাইজ করতে বলছে ক্যালকুলেশন আমরা
Okay, similar direction.
I am appealing for the petition.
For the state, you have.
15 hours. 15 to 20. 15 to 20. ওকে দিয়ে দিলেও 10,000 সুবিধা হয়। কিন্তু 22.
Three petitioners are there in this matter.
My lord. Item 14,
Item number 14.
my lord.
Three petitioners are there.
My lord.
Three persons have separate FPS.
Separate appears, but vacancy is the same.
Same vacancy.
Same vacancy. One vacancy. The three are affected by this.
Okay, similar direction.
And item number 15 to 22. I am for the petitioner.
for the state, my lord.
In all the matter, you are for the state.
No, no.
কোন কোনটাতে আছে? একটা একটা করে বল।
Let me just wait. Item number 15.
And I am for the petitioner.
I'm for the state, my
You are for the state.
lord. দাদা শোনেন বল হ্যাঁ এই যে
Okay. Similar direction.
But I am for the petitioner.
না না কেটে দিতে
Who is appearing for the state?
কিন্তু আছে?
মিস্টার শেষানু বন্দ্যোপাধ্যায়
Okay.
নামটা দিন নামটা দাও
দিয়ে দিচ্ছি একটা লিস্ট করে দিই।
Similar direction.
এটা খাওয়ার এখানে রেখে চলে গেল।
ছয় আছে তোরা আছে
Okay, similar direction.
My lordship, I'm for the state respondent.
Okay, similar direction.
I'm for this statement. এটা লাগবে কিন্তু কত নম্বর আইটেমে থাকবে এটা? নম্বর
Both of the petitioners are the partners. Similar direction.
20 কে আছে।
Who is for the state? Is there anyone appearing in this matter? Not appeared. Despite service. Similar direction.
Sure. 21 মানে আমাদের স্টেট লর্ডশিপ কি করবো দিয়েছে চাঙা পরিস্থিতি I think lordship has passed an order of affidavit, I think.
Similar direction.
Oh.
রিপোর্ট দিতে বলছে
যতক্ষণ আমাকে দিয়েছে ব্রিফ আমি কি করব
Report in the form of affidavit be filed by the state respondent within 4 weeks
লর্ডশিপ
from date. Exception thereto, if any, be filed within 2 weeks by the petitioner. Thereafter,
লর্ডশিপ
considering the submissions, the state authority may proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued till the disposal of the batch of appeals
লর্ডশিপ
pending before the learned division bench, being mat number 1543 of 2024
লর্ডশিপ
and others.
লর্ডশিপ I'm grateful. আরে ফালতু কথা বলছে।
I'm for the petition.
আসল কথা করি। আরে কি হয়েছে?
I'm for the petition.
Yes.
এত শেষে ক্রিমিনাল
Class.
Kunal is here.
Okay, similar direction.
23, my lord, I am appealing.
Three petitioners
My lord,
running three fair price shops.
my lord,
Aggrieved of the same notification.
same one.
Okay, similar direction.
My lord, item number 42 and 43 are similar, my lord. 43 C is here, my lord. And 42
স্বপন কুমার দত্ত is appearing. স্বপন কুমার দত্ত is appearing. 42.
40?
42 minus স্বপন কুমার দত্ত.
for
Okay.
state.
For the state.
Well, I am giving a great service, my lord.
Ayyo.
Give me 42 first.
40. There are three petitions.
Same three petitioners.
Three petitions, 42. And 43, 1.
Okay, similar direction.
वो खोज रहा था, बहुत देर दिख नहीं रही है मुझे। ये बोली बोली हमारे पास है।
Okay, similar direction.
Deep level है मैं।
Other matters. Takes up other matters by and order dated 7th August 2024. Your Lordship, we should direct the petitioner to file the notes of argument. File the early morning.
What is the number?
Have given the order copy. Lordship, please to make the matter CAB. Acted the
Okay. Enterprise.
amendment. With judge, your Lordship, please to act.
Chamber. Call item number 24. None appears on behalf of the parties. Office to report regarding the submission of affidavit of opposition and reply. As per direction of this court dated 10/7/2020. Let the matter go out of the list. Parties are at liberty to mention. Same order. Same order as 25/4.
Lordship 26, Lordship.
26.
Yeah, yes.
Direction pass. एक ही है. हाँ. Yes, who is appearing for the petitioner?
Yes, Lordship. I am for the petitioner, Lordship.
What is the affidavit of service?
State is the only respondent, answering respondent, I believe, your lordship. Let me see. কোনো private respondent আছে? Anwar Hussain, না? Similar direction.
Similar direction. But where is the affidavit of service?
Lordship,
Affidavit of service কোথায় আছে?
Lordship, I don't have brief, Lordship. It is.
না তো তুমি in the course of the day file করে দেবে.
Yes.
Yes, Lordship.
Similar direction. You file the affidavit of service.
Yes, yes, Lordship. 27 is same, Lordship.
Who is appearing in this matter? For the petitioner.
Into state.
Where is the affidavit of service? In the earlier matter, you are there.
Yes, sir.
Give me the affidavit of service of item number 26.
Item number 24.
Item number 26. Give me the affidavit of service of item number 27.
28.
One is appearing on behalf of the state. Despite service, none appears on behalf of the state. Similar direction.
Twenty-nine. Order of petition,
না না কিছু না. Similar directions.
state. Final.
Similar direction.
I will be after similar matter. 30 minutes I am for the state.
একই order pending subject to
Item number 30, you are appearing for the state.
lordship.
Okay, similar direction.
Lordship. Grateful lordship.
My lord, I'm for the state. My lord, this is a group 9 matter, my lord.
Who is for the petitioner?
Petitioner was here, my lord. Matter has to be released, my lord. Okay, time চাইবে?
Yes, which for the petitioner?
Sir, my seat is in another court room. So kindly short pass over and bring it.
I'll kindly come.
Is the matter within my determination?
No, ma'am.
Excise commission.
Group 9 matter, ma'am.
Excise commission is direct.
Group 9.
Hmm. Please take down. This matter appears to be not within the determination of this court. According the matter be released, petitioner is at liberty to approach the appropriate bench with determination, having determination.
Grateful, my lord.
If we ask for the matter will not well is being dealt by the division bench PI. We need to tag this matter along with PIL matter because this part
How can I tag?
Lordship can direct the matter to be placed before the Honorable Chief Justice so that it can be tagged with the WTA.
I do not know what is the matter going on before the Honorable the Chief Justice.
I have the orders. I have the orders. I am actually seeking similar relief. Kindly
Give me the order. Have you served?
Yes,
Steady, sir. Steady is the answering. And this is delayed.
Yes, madam. What is the matter?
yes, your lordship, it is with respect to sawmills. They say that they are operating without license. Many facts have been concealed. But this, I don't think lordship will have the determination.
Yes.
Yes.
Very well. Please take down.
Yes.
Learned counsel for the
Now it
petitioner
is gone.
as well as the learned counsel appearing on behalf of the state submits that
Baba.
similar direction was passed by the honorable by the bench of the honorable the Chief Justice, by the bench comprising the honorable the Chief Justice. Considering the submission, it appears that the instant matter not within the determination of this court. Accordingly, the matter be released. Full stop. Parties are at liberty to approach the appropriate bench, having determination.
My lord, you will kindly pardon me for the intervention. My item number was 25. I missed it by the second.
Item number?
25, my lord.
Item number 25.
Yes.
I have already called it.
Yes, my lord, I missed it by the second. It was already item number 26 was taken, and therefore I'm.
Item number 25, I have already passed the order.
My lord, we kindly considered, since on the earlier occasion, exchange of affidavit was directed, but no affidavit was also served
Yes,
upon.
that's why I directed the office to report whether affidavit was filed in the report or not. Thereafter, the matter will appear. No issue.
My lord will kindly mark our presence in the matter.
Matter?
Appearance, my lord.
Yes, your appearance may be. No issue.
Grateful, my lord.
I am for the petition.
Sir, 38. I am for the Union of India led by learned TSJ. Respondent number 1.
The defendant is appearing in this matter as my senior. Kindly pass over for at 2 p.m. Pick up at 2 p.m.
2 p.m. today. Today, 2 p.m. I have a special fixed matters.
So then I can proceed. Then I can
You can proceed. You are competent enough.
also.
Yes, yes. What is the matter about?
The application is challenging the selection process made by the HPCL for dealership in the district of Bakura.
Yes.
And kindly have a look at page 20, the advertisement.
Serial number?
The event is page 23. 114 serial number. It's a
114.
one on. Is the dimension of the land as
Within 2
mentioned in
kilometers, Jhoria High School.
Korea High School on Shaltora to Shanti Pahari Road, SH8. Is the Bakura regular? Kindly have a look at 6th column. 30 and 30. That is the dimension of the land. Depth, frontage, depth.
No, no. What are you referring? Regular 100.
Is the estimate monthly sales potential. That is 100. The category is
SC.
The category is SC. The type of site is CFS.
Yes.
And the frontage depth area is 30-30, that is 900. Now, my lord, I'm placing before your lordship.
What is the 900 area?
900 square meter.
900 square meter.
That is the area required for
Minimum dimension required for
making the plant or the dealership.
yes.
Now, kindly have a look. The necessary parties are Hindustan Petroleum.
Respondent number, they are the Hindustan Petroleum. Their appearance is necessary, because everything has been issued by them.
And you are appearing on behalf of whom?
Union of India, my lord. A formal party.
Union of India is not the party.
Union of India is a
He is the respondent number 1.
He is the party, but he is not the respondent.
Yes.
He is the respondent, but he cannot say, you cannot say anything.
My lord, sir.
Answering respondents are the 2 to 4.
Hindustan Petroleum.
2 to 4.
2 to 4. Have you served?
Yes, sir.
Yes, proceed.
Now, kindly come to page 70. There are some
Page?
formalities. Page 70. 70.
7.
There are some formalities which need to be.
Now, what is your case?
The case is that the petitioner is the legitimate one who is the ultimate one to get the dealership. But surprisingly, the private respondent has had been selected for such dealership. Even he has not fulfilled all the criteria.
Have you served on private respondent number 8?
Everybody.
Where is the track report?
It has been duly delivered. But
Give me the track report.
action for the day, I shall give
Yes.
it today. Tomorrow.
Not today.
The same position. Because either the selection they will execute the agreement. For that reason, I am very much worried about that.
So what do you want?
The selection has been over, and they are going to execute the agreement with the private respondent, the EPCL.
Then come on tomorrow then.
I am just praying for a
Interim order. On
at the same position, my lord.
the position would be maintained. No issue. It will be there in the same position.
Okay.
Nine, Your Lordship, I am appearing for the writ petitioner, Your Lordship. 39, Your Lordship. I was praying, Your Lordship. I am being led by Mr. Saptangshu Basu, senior advocate. There's some difficulty this week, Your Lordship. Would kindly take it up on Monday. In fact, I have served everybody. The affidavit was
Monday is the holiday, I think. It will be
on
on next
Tuesday,
week,
Tuesday, Your Lordship.
not this week.
Oblige, Your Lordship.
Madam, I am for the petition. But may I file my affidavit service, madam?
এটা হচ্ছে
Yes.
In 2022, my lord, a vacancy was published by my lord the state respondents regarding my lord fulfillment of a EMA distributorship. Now, your lordship may recollect, a few days back, that in connection with this vacancy, my lord, I had moved an application for my lord addition of party, and your lordship was pleased, my lord, to allow my application for addition of party. Now, my lord, in that writ petition, my lord, an order was passed, which your lordship would find, my lord, at page 81, my lord. Kindly, my lord, have a look, my lord. But there was an interim order passed, my lord, in that writ petition that, my lord, the respondents would not be, my lord, finalizing, my lord, any. And may I place this order, my lord? At page 81, it's, my lord, the paragraph starting with, in view of the point taken by the petitioners that in the central order of 2015, there is no provision for a distributorship. Let the respondent not finally appoint any candidate in respect of the vacancy notification in question. However, they shall be entitled to otherwise proceed with the selection process. Now, my lord, I have made my application. There was an inspection. Inspection was carried out in the order that prompted me, my lord, to file an addition of party before your lordship. And if your lordship kindly recollects, your lordship posed me a question that I may not be a proper party. I may be a proper party, may not be a necessary party for that implement in that writ petition. But your lordship, my lord, for the purpose of adjudication, my lord, allowed my application. Now, my lord,
Allowed your application to implead you a party in this matter.
yes, in this writ petition.
22279.
Yes, lordship.
In this matter, you have made a party.
Yes.
Very well.
Your lordship would find that order, my lord, at page
42
হ্যাঁ হয়েছিল রে।
এখানে
হ্যাঁ,
edit
42
না না মানে এই রিপিটিশনের পার্টি
হ্যাঁ পাঁচটা দেখলাম না। কোনটা কি বলছো বলো? Just give me a moment, my lord. Now, my lord, the writ petition which was filed, my lord, by Mr. Bhattacharya, that writ petition, my lord, has now become infructuous because, my lord, of the judgment that has been delivered by my lord Justice Vivash Patnaik, my lord. Wherein, my lord, it has been held, my lord, that the state government has the power, my lord, to proceed with the vacancies. But my limited prayer before your lordship would be, in terms of the order, my lord, at page 81, let the respondent conclude, my lord, the selection process. May not, my lord, grant me the license, but at least conclude the selection process. But I may be, but I should know my fate.
License is there to proceed with the
But
election.
they haven't. That is pending since 2022. And I believe that they have filed appeals, my lord. Appeal is pending before the Honorable Division Bench.
I don't know whether I have been made
No,
party
you have
so
not
far.
been made a party because
My writ petition order has been passed.
yes.
So far that writ petition that has not
What
yet.
is your prayer in this writ petition?
Yes, your lordship kindly comes, my lord. Your lordship would find at page 18, my lord.
What you want? You are
18, my lord.
one notification was issued in the year 22.
That is the vacancy notification, my
Vacancy
lord.
notification. It was challenged by one other parties.
Right.
The order was passed. In the writ petition, you made party in the writ petition.
Yes, for addition of party because I made an application.
Yes. you
My
have-
application
then
was pending.
what you want now in this writ petition?
But in this writ petition, I want a direction upon the respondents, my lord, to take steps in terms of the order that your lordship is finding at page 81 to conclude, my lord, the selection process. But actually, page 42. But in any case, it is applicable for all the matters.
Without exchange of affidavit, the order cannot be passed.
But I should be made a party.
But kindly,
And in my writ petition,
kindly seize my prayer.
my writ petition order has been passed, restraining them to
My lord, have I, my lord, prayed for, my lord, issue of license, my lord? No.
be made a party.
Well, then let him file an appeal. If he agrees, my lord, by that writ petition has been dismissed, has become
I
infractive.
have filed the writ petition wherein my order,
Your lordship
by
kindly
the
comes to
order
page
in
18,
which-
my writ petition, my lord, may I complete, my lord?
definitely you will.
Well, page 18, my lord, issue a writ in the nature of mandamus, commanding the respondent authorities and such to finalize the selection process initiated by notification dated such and such.
And who are you?
But I have made an application, my lord, if in this vacancy, my lord, your lordship would find my application, my lord. It starts from, my lord, page 33 is the acknowledgement, my lord.
You are also one of the applicants
Yes, my lord, in that vacancy.
in that vacancy,
Yes, my lord.
which you are challenged before this court.
Yes.
So,
I have not challenged the vacancy, my lord.
okay, you have not,
I have challenged.
other persons have.
I have
Other
challenged.
persons have challenged.
So you made party in this matter. So what is your prayer now?
My prayer, my lord, to conclude the selection process, which was the direction passed in the earlier writ petition also at page 81.
Why would not made the prayer, made the petition before that court, that writ petition?
In that writ petition, I have made my addition of party, your lordship. Your lordship,
You made addition in parties, you have allowed.
yes, my lord.
You may file any application there.
But that writ petition, my lord, was challenging the vacancy, my lord. The veracity of, my lord, the vacancy. Now, my lord, in similar matters, my lord, order has been passed, upholding, my lord, the vacancy. So, my lord, in effect, my lord, that writ petition, my lord, today, my lord, has become, my lord, infructuous, my lord.
Order of appeal, appellate court has the order.
But, my lord, in this writ petition, that order, my lord, they have not carried out any appeal, my lord.
Dismissal order has also not been passed. What my learned friend is saying, in this petition, no dismissal order has also been.
I'm not saying, your lordship, my lord, I'm not praying for an issue of mandamus that grant me a license. I'm saying the authorities ought to have, my lord, conclude the selection process. I'm not saying they issue me a license. But my application is pending since 2022. Today, we are in the verge of mid of 2024.
No, you know that the matter was stalled or stalled
That
by the order
prompted
of
me
this
to
court.
come before your lordship in addition
That's
of
why
party.
you have made addition of parties. Just a chance is taken to make a addition of parties.
Well, addition of party was, my lord.
No, you have not. You have entered in the proceeding. You have already entered in the proceeding.
Lordship.
So made a submission be there. Why the separate cause of action?
But, my lord, in that writ petition, my lord, the main prayer was, my lord, whether, my lord, the state government can publish a vacancy or not. But admittedly, my lord, that order has been stayed. But there is an order, my lord.
If thereafter on appeal is preferred.
Yes, appeal is preferred, that order has been stayed. But, my lord, that order is there, my lord. But today, my lord, the appeal may be allowed, appeal may be dismissed, my lord.
Subject to fate of the appeal.
Yes. So I'm not saying that your lordship would pass any order directing the issue, respondent authority.
Order is already there. That order is already there.
81 I'm paying before your lordship, only, my lord. Nothing more, nothing less, my lord.
This vacancy may not already an order persists that the state government is to proceed with the vacancy and it should not finally appoint.
Yes, a specific order is there.
In this writ petition also, that improvement is there. So
that may be done, my lord.
impediment is not there because we are proceeding with the vacancy. Notify the fate of
What is the purpose of again passing any order?
Because your lordship
Similar
kindly
nature.
appreciate, my lord, kindly takes up the vacancy notification, my lord. But kindly takes up the notification, page 29, my lord. But kindly see the conditions, my lord. One of the essential condition is, my lord, that the applicant, it starts from, my lord, page 29. And the predicament of the petitioner is, my lord, it starts from page 29, clause 6. The applicant must fulfill the following eligibility criteria. Have your lordship got, my lord? My lord, the last criteria, my lord, D. May I place, my lord? Applicants for distributorship must have a working capital of rupees 25 lakhs on the day of application in the form of saving account, current account, and of fixed term flexi deposit in the bank and or post office, and such working capital shall continuously be maintained till the grant of license. But 25 lakhs money is not a small sum of money. But I am keeping this working capital since 2022. Today we're in 2024. But if I know the fate of my application, with a caveat that the license may not be issued, but I can utilize that amount for some other purposes, my lord. It's stuck, my lord. Well, had the authorities, my lord, had proceeded, my lord, with the direction passed in appearing at page 81, but I would not have come before your lordship, my lord, in this writ petition.
You know the authority cannot proceed due to the pendency of the
But authorities can proceed. They will not finalize, my lord, the grant. They will not grant me the license, but they can conclude, my lord, the selection process, as has been done in many other cases.
Direction is there, all the cases direction is there.
The Lordship,
similar
those, my
nature.
lord, the respondents,
And
my lord.
why you want similar direction again?
Well, you see, whatever my learned friend is saying, that however, they shall entitled to otherwise proceed with the selection process. Proceed with the selection, but does not mean they will declare who has been selected or not.
And that
What
is
my
what
learned
we
friend
pray.
is saying, that cannot be.
Understand, I understand. Similar nature order has been passed in every cases. You know the matter, why
Yes,
the
I
matter
know.
was told. Why you again another order?
But that writ petition which my learned friend has filed, my lord, where I had filed an addition of party, my lord, the main prayer was, my lord, regarding, my lord, the power of the state government to issue such vacancies. My lord, I came before your lordship with an addition of party saying that my application is there. Due to pendency of this writ petition, my lord, the authorities probably are prevented from taking any steps or further steps. Kindly implead me, because I would like to make my submissions regarding whether the state government has power or not.
You have been implemented as a party to
Lordship.
respond.
Now, my lord, in the interagnum, my lord, in similar writ petitions, my lord, the order is passed, wherein, my lord, the power of the state government is upheld, my lord. Now, rightly, my lord, the aggrieved parties have filed an appeal, not in this writ petition. Your lordship would not see a single prayer stating, my lord, a mandamus upon the authorities to issue any license or, my lord, to issue anything. What I am saying only, my lord, kindly comply with the direction of page 81. Very limited prayer before your lordship, my lord.
Have you any evidence to show that they are not proceeding?
My lord, last, my lord, your lordship would find, my lord, I believe, my lord, the respondents would be at a better, my lord, position, my lord, to say
Very well.
have they taken any steps or not.
File objection.
They should have been made me a party.
What for?
My writ petition order has been passed.
No,
And he is trying to implement the order in my writ petition. He will not make me party. Whereas in my writ petition, he has been added as a party respondent.
Well, not tomorrow, my lord. Any other days of not.
please take down. Having heard the learned counsel for the parties, it appears that the incident writ petition cannot be disposed of without exchange of affidavit. Accordingly, the state authority is directed to submit a report in the form of affidavit within 4 weeks from this date. Exception, if any, by the petitioner be filed within 2 weeks thereafter. Affidavit of service filed on behalf of the petitioner taken on record. Let the matter go out of the list. Parties are at liberty to mention. You file it.
Your lordship has made the matter renewable or
Out of this,
My lord, in this matter, I am intervening. What has happened, my lord? He has not made me a party. I was the partner of this firm. In 2011, the petitioner resigned from the partnership, and the license, I have made a prayer for grant of license in my sole name. And that matter is already heard by your lordship, wherein he asked for an addition of party. And that both the addition of party as well as my writ petition has been heard by your lordship. The matter is here with your lordship. Now he has come without making me a party, asking for restoration of license in her favor.
I have asked for your lordship for implementation of the order passed by this honorable court or not yet. And on earlier occasions, after
On earlier occasion, you have filed 2 writ petitions. 2 writ petitions. After you have inducted her as a partner of 90%, and you have 10%. Thereafter, one application was filed on your behalf to surrender. Thereafter, you are not appeared. Your husband appeared and say, yes, your husband here, his wife has filed the application. The surrender petition was accepted by the concerned authority. Thereafter, cause of action arose that her name was not allowed to be a individual license holder. That's why he filed a separate cause of action. He proceeded 2 writ petitions. And you have also filed 1 writ petition before this court containing that the applications as well as everything, the petition which was accepted by the concerned authority was not your application. Not your application. The concerned authority has proceeded otherwise. And you have filed 1 application before the concerned authority to accept your prayer and induct him as a partner on the said business. That was turned down. Earlier turned down. Again, you preferred a writ. Then why you preferred this writ? Now, I know this fact entirely.
My lord, may I come to the latest order passed by the House. Page 40.
Yes, you are with a order of Honorable Justice Vivek Chaudhary. This is the last order.
Last one.
Last
But according to the
authority-
direction, I filed a representation before the District Controller Food and Supplies. District Controller Food and Supplies was pleased to hear me and had given a personal hearing. But till date, he has not communicated his decision to me.
Okay.
So, my lord, according to my humble understanding, that order passed by this court on earlier occasion has reached a finality. Until and unless the District Controller Food and Supplies takes a decision on this issue and communicates to me, he cannot proceed further with declaration of vacancy. So my humble prayer before this court or before your lordship, that they should be directed to restrain from proceedings with the intended vacancy until they pass an order in the matter of representation submitted to them.
My lord, so far as I know.
Now,
the
what is the
vacancy-
direction of this court? Let me see.
My lord,
Since it is ascertained that before cancellation of the license of the petitioner, the MR dealership was run by a partnership business, the District Controller Food and Supply is at liberty to issue notice upon the another partner if he wishes to hear him to solve the dispute appropriately and permanently.
but no notice has been issued to me, my lord.
But my lord, the added party, the intended added party cannot have the license since her husband is holding a license.
No, that is altogether separate issues.
Under the UPDS control order, she has no right
You see
to
the
obtain a
prayer,
license.
see the prayer, my lord, what he is seeking.
No,
And-
the authority was not specifically directed to call the
No,
other parties.
right.
If authority desires, he may, if he wishes to hear him to solve the dispute, he can. This is the direction.
My lord, so I
So
was
it
not told,
it is
I
the
am not making any prayer for that. But kindly see the prayer in this writ petition, what he is asking for. He is asking for grant restoration of license in his favor. Kindly see the prayer. submission is different from the prayer. Page 19 of the petition, my lord.
Restore license to the petitioner without further delay.
Yes. And my lord, B. Can you see the prayer B?
My lord, it was the contention in the representation submitted to the district
Number
controller.
4, to the responsibility.
So I have come up before your lordships with the same prayer as had been made before the district controller. And there are reasons to believe that the purported cancellation order of my license has not reached finality.
No, your order of cancellation is supported by your application.
Supported by my application, my lord, but subsequently I
If you
admitted.
challenge your application in any other forum that it was a forced.
No.
No, my
signature
lord.
was forced, then
No, my lord,
whatever-
subsequently I made a representation that the application for surrender of license was made inadvertently by mistake. And I wanted to withdraw that applications, but they
After 2 years,
found that,
after 2 years of submission
My
of the
lord.
application and after 1 year of the acceptance.
my lord, that's true. But in 2011, they have stated that in 2011, they have accepted my resignation.
Yes.
But till 2016, they have renewed the license. If my resignation was accepted, the license turns to non-est. How can they renew in 2016?
By virtue of the order of this court.
Maybe the other issue involved in this case, that until and unless they refund my security deposit, the purported cancellation order cannot reach finality. Have they returned my security deposit? Let them say.
You can claim it, no issue. With interest, you have to get it.
So far as my lord vacancy is concerned, your lordship has already passed an order in another writ petition not to grant license.
Yes.
Therefore, that order is also not necessary now.
Already order is there not to grant any license. Already order is there. Fresh license before determination of that matter.
Yes.
You have made an application before the,
District controller.
no, before this court in the application filed by the, what is the name? Jahanara
Nazia Begum.
Nazia Begum.
Nazia Begum.
Nazia Begum.
Ah.
Nazia
And
Begum.
I was made I paid for an additional
Addition of
party.
party.
Yes. And I was allowed to be added at a party.
No.
Not
No, no,
allowed.
no.
Not allowed. The argument was heard. It was made for passing order along with the
Writ petition.
writ petition. This is the order. So now what you want?
My lord, until my representation.
I can pass any order to the concerned authority to act according to the direction of this court. Only.
My lord.
Only this order can be passed.
My lord, in
And not to proceed with the purported vacancy notice.
Already it was stayed. Already it was stayed.
My lord, only
By the in that period.
another.
Then my lord, the authority should be concerned, directed to consider my prayer.
My lord, subject to your lordship approval, my lord, if this order has not been implemented by the authority, he could have gone for the contempt. How can there be second?
There is no time bar. There is no time bar for disposal of the representation. And unless there is a time bar for disposal of the representation, I cannot
why no
move
time
to
was
this
given.
court for contempt.
By giving a notice, either pass or I shall have to move contempt, and always contempt petition can be filed.
Have you made any representation before the authority?
Yes, my lord.
Where is the representation? No representation is there in the writ.
Counter. Super. C7.
P7 page.
One small letter is there
Page 38.
for appearing before the on hearing.
Page 38.
Page 38, my lord.
Page
38.
38.
It was received by then on 6 June 2023.
page 38.
6 June 2023. Now we are in August, more than 1 year. He waited for more than 1 year.
No, 6 June 2023 is the order prior to the order passed by
It
this.
was the earlier dispensation.
No, after the order passed by this court on 20th July.
That representation has to be considered.
order dated 20 July.
No,
By-
then you have to file one separate representation. Otherwise, how can I deal with this? If you file one representation, they may have answered your representation.
But they have already heard me.
Yes, I know they have heard me. You are entitled to have the result. Just you file an application.
Another
If-
representation to them,
If they have not answered your representation, then you can come.
my lord.
Okay. I am disposing as withdrawn. File afresh if required. Okay. Having heard the parties, the petitioner submits that he intends to withdraw the writ petition with a liberty to sue afresh. Considering the submission, with a liberty to sue afresh. Sue afresh. At all the instant writ petition is disposed of as withdrawn with a liberty of petitioner to sue afresh.
I've got the respondent. My lord's order dated.
Yes.
My lord's order dated 3rd July 2023. A slight correction is required, my lord. Page 1, 5th line, my lord. Page 1 of my lord's judgment. Page 1, 5th line. Instead of women's compensation, it should be, my lord, workmen compensation.
Yes.
Actually, as the lower court record was not sending down, so I searched for it and the department told me that.
Very well, very well, very well. Only this, please take down. This matter appears for correction. In judgment dated 3rd of July 2023, at the first page, para 1, in 5th line, the term women's, WOMEN apostrophe S within invited comma মধ্যে রাখো, shall be read as workman's within invited comma মধ্যে রাখো workman's টা, full stop. The office is directed to make the necessary correction in the impugned judgment within a fortnight.
My lord, urgent zero certified to my lord, and the lower court record be sent down, my lord, immediately. My lord.
Let the urgent certified copy be provided to the parties if applied for. As per the office is directed to send down the LCR special messenger
My lord.
through a special messenger, cost to be borne by the petition. Petitioner is
I am the respondent.
cost to be borne by the respondent. Full stop. The respondent is directed to submit the special messenger cost with the department within a week.
My lord.
Within a week? Within fortnight or week?
Within a week, my lord.
Within a week.
And
Very
the lord could be directed, my lord, to pursue the matter as earlier. With no application. Lord could,
I think direction is there.
but there is a direction. Appeal filed by the appellant was dismissed, my lord, a direction be given, my lord, actually more than 1 year has passed, my lord. They are suffering a lot.
Learned Tribunal is directed to comply the order passed by this court within 2 weeks of receiving of the LCR. Positive.
If you okay,
My lord, this is my
The last occasion, your lordship asked them to get instructions.
my lord, it has already been admitted by the OPs, my lord, that there is a that the petitioner is entitled for 6,40,000
They are already admitting.
admitted. Now, my lord, my contention is that the claim is much more higher as because, my lord, why I am to be given, my lord. First of all, my lord, in my prayer and the petition, my lord, I have already claimed that 20.
No, we are in CO jurisdiction, not in appellate jurisdiction.
Yes.
You know my limit. If I've been in the appellate court, then I can enter into your submissions. But in CO, I cannot go into the merit of the entire compensation case.
But under Article 227, your lordship can enter in the fact and, my lord, consider the entirety of the matter, my lord. And, my lord, I beseech before your lordship and
order
lordship.
was challenged in the appeal. Thereafter, the order was went to the Honorable Apex Court. Now you
No, my lord, appellate order has not been challenged.
Then you challenge it.
No, my lord, I am not on this point, my lord. Last occasion, I have submitted that the entire litigation has been protracted, my lord, at the
Yes, that you have submitted order.
Yes, and my lord, I am amplifying on that point only, my lord, not more than that. Because this protraction, my lord, I have sustained injury, and my lord, if my lord, there is a possibility for claiming damage because of the injury I have sustained, then only, my lord, your lordship consider the section 35A last clause, last proviso, my lord, of the Civil Procedure Code. The amount of any compensation awarded under this section in respect of the false or vexatious case or defense shall be taken into account in any subsequent suit or damages or compensation in respect of such claim or defense. That means, my lord, that is section 35A, subsection 3 and 4. No person against whom an order is made under this section shall by reason therefore exempted from the criminal liability in respect of any claim or defense made by him. So, my lord, the defense which they have taken, my lord, that is a false defense, and on the basis of that, my lord, litigation is highly protracted. This is my first submission. Because, my lord,
no, what you are referring? Referring 35A subclause 3.
Subclause from the last provided further high court.
This is compensatory cost in respect of false and vexatious claim of the claim or defenses.
Yes.
Very well. So you are referring a subclause 3.
3 and 4. When the defense is vexatious. They have not sustained their.
Is there any order that the defense is vexatious?
My lord, they have not. My lord, kindly come to the order passed by the Honorable Justice Sobhashachi Bhattacharya in CO number 3858. That is in my synopsis. And being the synopsis page number for the Shina. This is the order dated 4 July 2019. Being Annexure C of my synopsis.
Yes.
My lord, I am coming to the operating part of the
Page.
Internal page 3, last paragraph. Learned counsel for the petitioner argues that opposite party was represented before the division bench. That is when the order of 10% penal interest was made. When the order dated 29 September 2016 was passed, as such, there arose no question of any further communication to the respondent regarding such order. Communication made by the petitioner through the advocate was only a reminder to the opposite party for compliance of the direction, not communication as mentioned in the said order. Moreover, it is argued that there was no specific direction to the petitioner to communicate the order to the opposite party. As such, the opposite party could not take shelter under the alleged late communication to be deprived the petitioner to the additional interest of 10%. So, my lord, they have an intention to deprive the petitioner per annum payable for failing to disburse the sum, directed the division bench within time. Learned counsel for the opposite party submits that the opposite party fully complied with the direction of the division bench. That is their contention, and it's a false contention. Submitted that disbursal was made within 2 weeks from the date of communication in the order of the division bench by the advocate for the petitioner. The learned counsel for the opposite party cites a judgment reported in 2019 3 SCC, that is Union of India versus Rina Devi, wherein it was held inter alia that rate of interest on compensation ought to be awarded at a reasonable rate at per accident claim cases. Now, my lord, they have not, though in the revisional jurisdiction they have cited, but they have not challenged the main 10% penal interest before passed by the division bench. Relying on the same judgment, it is argued that the court have to be reasonable in awarding interest and take a pragmatic approach in deciding such cases. As such, in view of the compliance of the direction of the division bench, in substance, no further order is required to be passed by the tribunal. A perusal of the judgment of the division bench in question makes it clear that division bench reserved to qualm on the question of payment of interest to the rest of 6% per annum over the entire awarded sum with effect from 6 January 2003 till deposit of the sum. Although it was recorded in the said order that sum shall be deposited by the respondent in a period of 2 weeks from the date of communication of the order, the interpretation of such communications as proffered by the petitioner would be absurd and stand contrary to the letter and spirit of the division bench. It was the specific mandate of the division bench in issuance of the presence of the advocate for the respondent that amount was to be paid within 2 weeks from the date of communication of the order. Even taking a pragmatic approach, the date of communication has to be fixed in the fact of the case as the date of passing of the order, since the opposite party was represented by the counsel at hearing. Moreover, in view of the present existence of the fast communication modes, including telephone and internet, it would be absurd to hold that communication could take more than 24 hours. Particularly in view of the specification that following the payment and additional interest of 10% per annum was to be paid by the opposite party. Even attributing a wide parameter to such interpretation, no liability can be fixed from the tenure of the order on the petitioner to communicate such order to the opposite party under any stretch of imagination. In particular, since the opposite party was represented by a counsel, as it is evident from the said order itself, communication, if any, would have to be by the counsel of the opposite party to the opposite party. Such a communication could take more than a day, and as such, it has to be presumed that 2 weeks period as contemplated in the division bench order dated September 29, 2016 started on the date of the order itself. As regard the judgment cited on behalf of the opposite party, the same cannot have relevance in the instant matter. Since the quantum of interest in the present case was already adjudicated upon, initially by the tribunal, thereafter by the division bench of this court, upon adjudication of the division bench on September 29, 2016, such adjudication attain finality and cannot now be reopened. Another point taken by the opposite party is that the petitioner committed certain laches in filing the mandate from form for getting the compensation beyond time. Upon query from the court, it is submitted such deposit of mandate took place much prior to the order of the division bench at the time of applying the compensation. So, my lord, they are successively taking the false defense. It is apparent from the order itself. Such argument has to be refuted in the following score. First, such prior happening cannot have any relevant bearing to the order of the division bench, since whatever the laches could be alleged against the petitioner have to be post September 29, 2016, that is the date of passing of the judgment by the division bench. Secondly, the mandate form was mere a formality which could not deter the opposite party disbursing the amount as directed by the competent forum. That apart, the revision bench categorically directed that interest at the rate of 6% per annum was to be awarded over the entire sum with effect from 6 January 2003, leaving no scope of doubt as to any further requirement of filing the mandate form or other paraphernalia, which could come in the way of the opposite party dispersing the sum, such amount to the petitioner within 2 weeks from the date of ordering of the order of the division bench. In these circumstances, tribunal refused to exercise the jurisdiction, and my lord, when I have appeared before the learned railway claim tribunal and to execute the particular order passed by the honorable division bench of this honorable court, the executing court of the learned railway claim tribunal refused to entertain that order, which is tantamount to contempt. So, my lord, now, my lord, at this stage, my contention is that why the petitioner should not be compensated for this protracted litigation along with the railway authorities. So, in the circumstances, the tribunal refused to exercise the vested in the law, rejected the application of the petitioner being awarded the additional interest at the rate of 10% per annum for late payment of the amount directed by the division bench. Accordingly, CO number 3858 2008 is allowed on contest, thereby setting aside the impugned order and directing the tribunal to complete the entire proceedings within 2 weeks. Thereafter, my lord, I have come with that the calculation is faulty, and they have already accepted. They have accepted that.
They are coming before the court.
And my lord, this order, when, let me finish, I have not finished, and you will get ample opportunity. And when, my lord, this application has been filed challenging the calculation of the order passed by the learned railway claim tribunal, my lord, they have filed this SLP just to stall my claim. And it has upheld, my lord, the Honorable Supreme Court upheld the order passed by the my lord Justice Shobhashachi Bhattacharya. And my lord, it is apparent from the order, my lord, the entire thing has been protracted and on the grab of false defense. And there is no defense. They have to calculate and they have to pay. And last 5 years from 2016 to 2024, last 8 years, my claim has been withholding by the opposite party. And that is the reason, my lord. That is the reason I am referring section 35A of Civil Procedural Code, as well as, my lord, my further submission is that, my lord, there is an earlier bench has already passed an direction was made upon them to file the limited affidavit in opposition if they desire so. But they have not filed. They have chosen to on the basis of the oral argument. And, my lord, if that be so, my lord, why my question is this, my lord, before me, my lord, why my entire claim should not be allowed following the provision of Order 8, Rule 10 of the Civil Procedure Code, as because they have not made any objection to my civil revisional application. And in continuation of this, my lord, I am cited an earlier occasion, my lord, I have referred the judgment, same judgment, I am stick to the same judgment, my lord, that is 2014, volume 8 SCC, page 470 and paragraph Miller starting from 191 to 194. Millard, I'm just reading this and handing over before your lordship. The Indian judicial system is grossly afflicted with the frivolous litigations. Ways and means needed to be evolved to deter the litigant from their compulsive obsession towards a senseless and ill-considered claim. One needs to keep in mind that in process of litigation, there is an innocent sufferer on the other side of every irresponsible and senseless claim. He suffers long a time. He suffers long drawn anxious period of nervousness and restlessness. Whilst the litigation is pending without any fault on his part, he pays for the litigation, which I have submitted in last occasion, form out of his savings or out of his borrowings, worrying that the other side may trick him into defeat for no fault of his own. He spent individual time briefing counsel, preparing them for his claim. Time which he should have spent at work or with his family is lost for no fault of his. Should a litigant not be compensated for what he has lost for no fault? This is a question made in this particular judgment, my lord. The suggestion of the legislature is that a litigant who has succeeded must be compensated by one who has lost. The suggestion to this legislature is to formulate a mechanism that anyone who initiates and continues a litigation senselessly pays for the same. It is suggested that the legislature should consider the introduction of a code of compulsory costs. We should not be taken to have suggested that the cost of litigation should be enhanced. It is not our suggestion that court fee or other litigation related costs should be raised. Access to the justice and related costs should be as free, as low as possible. What is thought to be redress is a habituation to press the illegitimate claims. The practice and pattern is so rampant that in most cases, dispute which ought to have been settled in no time at all before the first court of the incidents are prolonged endlessly for the years and years from the court to court up to the highest court. Milord 91, 92, and Milord 93 and 94 almost echoing the same things.
191 to 194.
191 to 194.
Yes.
And my lord, in the last occasion, in earlier occasion, when the matter was moved before the earlier honorable bench, my lord, his lordship suggested me to file the synopsis with a calculation chart of outstanding amount, my lord. That is, I have given the here, my lord. After Roman 10, I have given the calculation chart, and my claim is 57 lakhs, 20,348. Last page. And they have already admitted that it's 6 lakhs 40,000.
How many you have received?
I have received 5 lakhs 71,130 plus 7 lakhs 14,000 and 7 lakh 14,328. That is
where you have stated this?
My lord, that is, my lord, it is in the calculation chart just last page before
Total awarded money of rupees 7,14,000.
7,14,328.
328.
328. আরে এটা এমনি ক্যালকুলেশন শিখতে না সিম্পল ইন্টারেস্ট করে ওটা এটার মধ্যে নেই
10% compound interest?
No. Yes, 10% compound interest.
Whether it is stated to be 10% compound?
No, it has not been stated.
Then?
So they are saying that 10%. This is my claim, my lord. And my lord, 6% 6 lakhs 40,000 is the admitted amount. They have already admitted, my lord. Now, my lord,
10%
my
awarded amount.
My prayer is that the
I have heard your prayer. So what is the amount? Let me settle the issue. What is the amount you agreed?
3 lakhs was the principal award amount.
Total award was
3 lakhs.
3 lakhs.
That
3
is
lakhs
on
or
page,
4
my
lakhs?
lord.
4 lakh.
4 lakhs was
3 lakh.
altogether for 3 persons, my lord.
Okay.
The wife was
3
given the
lakhs in
petitioner
favor
who is
of
before your
wife.
lordship.
Yes.
She was awarded 3 lakhs rupees.
Okay.
And rest 50,000 was with regard to the son and the daughter.
Son and daughter.
Very well. So 3 lakhs was award along with 6% interest.
6%, the award as well as the 6%
6%
amount has been
finished, my lord.
has been
No, I
paid to
understand.
them, my lord.
So you have received
The award has been received by them, my lord.
7,14,000.
As well as 6% the interest was received by them, my lord.
Yes.
The dispute is with regard to only 10%.
Penal interest.
Penal
of 10%.
10%, my lord.
So penal interest, 10% penal interest according to your calculation. What is the amount?
Awarded amount was 3 lakhs, my lord. That is for from the date of filing, that is 2003. So for 21 years, 21 years around it's
So
something
what is
odd.
the amount?
That will be
21 years,
That-
9 months.
6 lakhs something.
40,000 something. That we can calculate, my lord, exactly. Bullet. It comes to around 6,45,000. It is 21 years and 21 and half years.
Yes.
Because it's 2003, the order was passed. We are in 2024, my lord. So,
Do you have the mandate?
my lord will kindly come to the order of Honorable Justice Sabyasachi Bhattacharya, my lord. See what is the prayer was. My lord, I'll only read 2 paragraphs. The primary grievance of the petitioner in such appeal was that the interest has been imposed from the date of award rather than from the date of the accident, and that rate of interest ought to have been higher. This was the primary grievance, my lord. So now they are in that order. It was awarded that 10%. The division bench order was upheld, and it was said that 10%.
It was attained finality. No issue is there.
No issue.
No issue left.
No issue left.
So what is the amount I want to know?
My lord, the amount comes is 3 lakhs, my lord. That was the awarded amount.
So
2000.
10% penalty interest,
10% penalty.
6 lakhs 45,000.
6 lakhs 45,000 comes, my lord. It might be to some thousand of rupees.
What
might be
more about more than 6 lakhs 45,000?
something odd like that.
So you
Because the date of award is 2003, my lord. I'll tell you the 6/1/2003 is the date, my lord, from which it has to be calculated. We are on, my lord, 24. So it comes around 21 years, 5 to 6 months. That we have to calculate that 6 months. 21 into 3 is.
This is January 2003. So it is
January 2003.
That's why I'm saying
January-
21
so
years
it
and
is
6 months, perhaps 6
months.
to 7 months.
Whatever maybe. So when you shall deposit it?
That will be deposit within 15 days.
Within 15 days.
Right.
And Milord, for this protraction of the litigation and all, Milord,
Pass the order, no issue. Let me settle this matter first. So
My lord, then this matter went to appeal, my lord. We prepared the SLP. SLP was dismissed on, my lord, 6/15/2024. This year in the month of February. Immediately thereafter, we proceeded with this application. It's not that we have delayed that application. The
no,
matter
that
was
is not the
disposed
issue. So where you want to deposit?
My lord, we'll deposit
Directly to them.
No, we'll hand over the check to them in the court, my lord. Last occasion, we also handed over in the court itself, so that there is no issue with regard to them, because every time they come up with different calculations. We'll fix up after 15 days, we'll hand over the check. Check. Last occasion also, the check was handed over to them in court itself. They gave a receipt, my lord. It will be given in the favor of the petitioner. This was the, my lord. This was the check which was handed over to them. Subsequent to the order, we
Very well.
Lord, I'll tell you the exact amount. August, November, 8 1.
Okay, heard.
Select 30,000, 30,000 divided by 12. That one into 8 for divided by 12. Well, the amount will be around 6,47,500. It is for 21 years, 7 months. Since it was starting from 6/1/2000. 15 days more. Okay. It will be 6,50,000 if we take it till September, my lord.
Yes.
We will be, we are ready to pay 6,50,000.
Please take down. Petitioner approached Railway Tribunal for getting compensation on the ground of untoward incident wherein her husband was died in accident.
I take a family.
Yes. The Railway Tribunal awarded 3 lakh, awarded a compensation amounting to 3 lakh, together with 6% interest per annum in favor of the petitioner. Full stop. কি বললাম বলো? This person per annum লিখেছো from the date of award in favor of the petition. Full stop. Being agreed by the said direction, the petitioner approached to the appellate court, wherein appellate court has directed that the interest should be calculated from the date of filing of the application. Full stop. The division bench of this court has also awarded further interest at the rate of 10% per annum to be calculated from the date of application till deposit towards the additional interest full stop. The railway tribunal has not awarded the interest as directed by the division bench. Accordingly, the petitioner approached before this court in CO number 3858 of 2018. The a coordinate bench of this court has directed the tribunal to pay the compensation along with additional interest at the rate of 10% per annum as directed by the division bench. Against such order, the railway authority has approached to the Honorable Supreme Court in special leave to appeal number S within bracket 927 of 2020. The Honorable Supreme Court has refused to entertain the SLP. In virtue of the direction of this court, direction of the single bench of this court, the railway authority, the tribunal has passed an order on 19th of July 2019 regarding the calculations. Full stop. According to the petitioner, the calculations made therein is erroneous. Hence, the instant CO has been preferred. During argument, learned advocate appearing on behalf of the respondent submits and admitted that the calculation made by the learned tribunal is erroneous. He has specifically submitted that the the true purpose and purport of the learned division bench would be complied, and an amount of rupees more than 6,45,000 till today is unpaid towards the interest, towards the penal interest. Learned advocate for the petitioner submits that the submission of the learned counsel is correct in respect of the calculation of the interest. Full stop. Next paragraph. Learned counsel for the petitioner submits that the fact suggested that the present petitioner is roaming before the court in several forums to get the proper compensation. He submits that his husband was died in an accident on 20th August 1998. Since then, he is running pillar to post to get the proper compensation. He further submits that this is the instance of protecting litigation only to deny the proper compensation to the petitioner. He further submits that the defenses as well as the submissions of the railway authority in several proceedings are vexatious, are false and vexatious. So the petitioner is entitled to get compensatory cost. In support of his submission, he cited a decision of Honorable Apex Court in Subroto Roy Sahara, SHRA versus Union of India, reported in 2014 within bracket 8 SCC 470. Paragraph 119 to 194. Set out koro. 191 to 194. 191. 1199. 191. 191 to 194. Set out koro. Okay. 191. He also placed, learned counsel for the petitioner also placed the provision of section 35 capital A of the Code of Civil Procedure, wherein the provision is made for compensatory cost in respect of false or vexatious claims or defenses. Next part, learned counsel appearing on behalf of the respondent submits that the railway authority has not made any false or vexatious claims, vexatious defenses before any of the authority. The railway authority is always ready to pay the compensation as directed by this court. Learned counsel for the respondent authority further argued that the submission of the present claimant regarding the claimant of compensatory cost is not justifiable in the attending facts and circumstances of this case. Are the learned advocates peruse the observation of Honorable Apex Court in Sahara jeta bollam
And if your lordship kindly add one more line, that the respondent will proceed with the server copy. Because if I go for the certified ones, that will take time and the proceedings will be
Let me
delayed.
conclude first. Okay. The first issue regarding the payment of compensation in terms of direction of this court of additional interest of 10% per annum, 10% per annum from the date of filing of the claim application has already been admitted by the railway authority. Thus, the railway authority is directed to pay the interest, pay the amount upon the interest, upon the penal interest, upon the penal interest as per direction of the Honorable Division Bench of this court within a fortnight, through a check directly to the learned advocate, to the learned counsel for the claimant before this court. Full stop. The next paragraph, the railway authority shall prepare the check and disburse the same before this court on tenth of September. On or before 10th of September. On or before 10th of September. Full stop. Let them, the railway authority is also liberty to act upon the server copy of this order. Full stop. Let the matter appear in the list on 10th of September under the same heading. Full stop. Next paragraph. In considering the prayer for compensatory cost due to the act of the railway authority in protecting litigation, it appears to me that initially the claimants file a claim application before the learned tribunal, on the basis of which the defense was submitted by the railway authority. On consideration of the defense and the pleadings of the parties, the learned tribunal has awarded a compensation in favor of the petitioner. Full stop. The said defense was also was again second before the learned division bench in an appeal, wherein the learned division bench has allowed the interest portion from the date of filing of the claim application instead of from date of award. Full stop. The learned division bench has also awarded 10% 10% additional cost. Full stop. Thereafter, the petitioner approached to the railway tribunal to execute the award, which was not properly executed. Hence, he approached the this court in a CO, in a civil revision, in a revisional application, in a civil revisional jurisdiction, in a civil revisional jurisdiction. The order was passed by a coordinate bench of this court, directing the railway authority to comply the order of the division bench of this court positively. Against such order, the railway authority approached to the Honorable Apex Court. Full stop. The Honorable Apex Court denied to entertain the SLP filed by the railway authority. Let me consider the provisions of 35A, capital A of the provision of section 35A of the Code of Civil Procedure. the section 35 capital A deals with the false and vexatious claims or defenses of the parties. It is the claim of the present petitioner that the defense which was made by the railway authority before the defined authority are false and vexatious. I find no justification in the ground that no justification on the point that the defense of the railway authority is ever vexatious or false. Full stop. It further appears to me that the section 35 capital A is not at all applicable in this matter. Applicable in this matter. Next, in case of Subroto Roy Sahara, the Honorable Apex Court has deprecated the approach of the parties who appears to be the who appears to be before the Honorable Apex Court as a bench hunter or bench hopper. In the case of Subroto Roy Sahara, the petitioner has proceeded to the different judges when it appears to him that he would not get the favorable order. Full stop. The approach of the petitioner in Subroto Roy Sahara was highly deprecated by the Honorable Apex Court, and it has been observed that the act of the petitioner is grossly frivolous. Full stop. The case dealt with by the Honorable Apex Court in Subroto Sahara is not similar to that of the present case. Thus, it is distinguishable. Next paragraph. Considering the entire facts and circumstances of this, it appears to me that the learned division bench of this court has already awarded a compensatory interest upon the railway tribunal. The interest is running day by day. That's why I find nothing to entertain the present petitioner to pass an order for compensatory cost. On the above observation, the prayer for the present petitioner for compensatory cost is considered and turned down. Next paragraph. The present petition, the railway authority is directed to comply with the order as passed by this court positively by filing the checks, by handover the checks, by handovering, by
My lord, at least some cost is required to be paid, my lord, because the poor lady, my lord.
Comply the order. Checks. Full stop.
And your lordship kindly add one more line that the respondent will proceed with the server copy.
I have already passed the order.
September.
Yes. Next.
বইটা থাকবে না বইটা ঠিক আছে ঠিক আছে
Call the next matter. কি হলো?
Item number 40
দেখি
is disposed of. মানে ইয়ে হয়ে যায় না,
বুঝতেই পারলাম না আমি।
এখানে অর্ডার না হলে কিন্তু হবে না, বেরোতে হবে।
সার্ভার কপিটা একটু তাড়াতাড়ি আপলোড করে দেন আমরা তাহলে ওখানে অ্যাপ্লাই করা
হচ্ছে 2778 is the list. They send 12778. রং ফাইল চলে এসছে, অন্য ফাইল এসছে,
না না বুঝতে পেরেছি এটা
ফাইলও আসেন।
সেটা আমাদের কমপ্লাই করতে হবে তো
ঠিক আছে, রেখে দিন। ওকে, নট নেসেসারি। ভেরি
অর্ডার হবে তো? কিছু অর্ডার হবে এটা অর্ডার হবে
48, my I'm for the petitioners. It's matter, my lord. Petitioner being an OBC candidate,
Yes, where is the report?
That's why I'm praying for some extension. Because I'm
Again extension.
because personally I'm last week, my lord, I am due to my eye infection, Lord, so I'm not prepared.
Very well, very well. If it is your personal ground, then I shall not say anything. Very well.
ঠিক আছে আর চোখে
Interim order is till 30th August.
my lord.
Let
Lord,
it be
can you
there.
extend the interim order?
No,
is already till 30th of August.
already
এটা
30th
শুধু
August.
পারবে না আমাকে তাই
Is it possible within 30th August? The report? 2 weeks time.
Then August.
Very well, this need to extend.
চোখ দেখো না
জানি আমাকে
Okay,
বলেই-
please take down. Learned counsel appearing on behalf of the state authority. 6, accommodation for extension of filing report. Let the report of the state be filed within 20th of September. Full stop. Next para. The interim order passed by this court on the earlier occasion, which was extended till 31st August 2024, is further extended till 30th of September 2024 or until further order, whichever is earlier. Let the matter appear in the list. Again, date a copy from 23rd of September.
Grateful.
23rd of September.
কি পড়ে বলছো
2 তারিখের মধ্যে রিপোর্ট করবে, 23rd এ আসবে।
23rd ছুটি কথা
আরে আর কদিন
23rd?
This will be under the will appear under the same heading.
অ্যাপ্লিকেশনই আসবে
And I'm for the petition. Read today. মানে your lordship passed an order কবে on 13 staying the directing the respondent to proceed with the vacancy but shall not appoint any person, and while passing the order your lordship has recorded that petition is a fair price shop owner, but in paragraph 2 I have stated categorically petition is an intending applicant had challenged the vacancy. Your lordship kindly come to the paragraph 2. This should be recorded as intending applicant instead of
The petitioner is an intended applicant,
yes, my lord.
not the dealer.
Not the fair price shop dealer. That
Okay.
is to be required to be corrected, my lord. Can you go to paragraph 2?
I understand. Please take down. This matter appears for correction in order dated 13/8/2024 at page 1, paragraph 2. The paragraph 2 in page 1, the last 2 lines of paragraph 2 should be omitted, and in its place the undermentioned phrases should be written as follows. বলে এবার ইনভার্ট করুন। an intending candidate
Well.
for the state
Thank you.
fair price
I'm grateful.
the office is directed.
During this.
Prage. I don't know, office to incorporate the correction within a fortnight.
This is for extension of interim order, my lord. It has expired on 14th. And I am praying for extension till disposal of the appeals.
Appeals?
Yes, yes.
Where is the affidavit in opposition? Ready?
No, no affidavit has been filed, my lord.
Lordship, because we had liberty to, the state was given to file the affidavit in opposition, but before that, since the appeal had already gone there, therefore, Lordship, we haven't. However, the affidavit is ready. If your Lordship so wants, we can
do
it. Right.
Keep it yourself.
Yes, Lordship, we thought so, because now it is
as of now,
exercise in few times.
Yes, as of now.
Please take down. Learned Counsel for the state authority frankly submits that due to the litigation of similar nature pending for disposal before the learned division bench, the affidavit in opposition, which was directed to be filed by this court, though made ready, but was not filed. Full stop. Considering the submission, now heard the submission, it appears that the submission is made bona fide. Thus, the affidavit in opposition, which was directed by this court, is hereby extended for a further period of 3 months.
3 months.
The interim protection which was given to your Lordship.
Yes,
For 3 months. Full stop. Next paragraph. This matter, learned counsel appearing on behalf of the petitioner submits that the interim order passed by this court is going to expire very soon. So he prayed for extension of interim order. Having heard the parties, the interim order passed by this court on the earlier occasion is hereby made absolute till the
51
till the disposal of the
batch of appeals
pending
before the learned division bench.
Pending before the learned division bench of this court,
MAT
1543 of 2024 and others.
Let the matter go out of the list, my lord.
Let the matter go out of the list. Parties are liberated to mention.
A similar order in next.
51, same.
Item number 51.
Same.
Same interim order.
Same. Take it.
Come here.
Item number 54.
On this matter, I am appealing for the petitioner, my lord. So my learned friend has filed an application. Bracketing.
Lordship, I beg to appear for the added respondents. 2 parties were added, respondent number 5 and respondent number 6. So, my lord, we preferred one vacating application because we are suffering an ex parte interim order. Now there was
issue is pending before the learned division bench, my lord.
But in
And no affidavit has been filed by my learned friend.
Today we have come with an affidavit, Lordship. If I may respectfully file this affidavit on behalf of added respondent number 5, we have come up with. And my learned senior friend is referring to this issue is pending before the honorable division bench. I also do agree. But my lord, one part of the order which is passed by the honorable division bench is giving me protection. So far as respondent number 5 is concerned. I'm not talking about 6, but 5. Yes. Respondent 5 was already granted license. So he is not coming within the
domain of that status, Lordship.
But
But 6 comes.
so far, my lord, the division bench order.
Eito. Division bench order dated 14th August, it says. No, 6th August. Kindly hand over a copy. May I respectfully hand over a copy of the division bench order?
6, no, 14.
No, first order 6th August. May I respectfully invite your Lordship Miller to paragraphs 10 and 11.
No, what are you pressing? Can 2?
We are pressing
Yes,
Millard,
can
can do Millard, that is vacating application.
No, vacating application has to be heard along with the appeal. This is the order passed by this court already.
With writ petition.
I have already passed the order in 27th of June.
Yes, Lordship. So there was a direction for filing opposition.
Opposition, if the opposition ready, you can file it.
So Millard, our opposition there are 2 added respondents.
Opposition against the writ petition.
Yes, Lordship.
File it.
Vacating application is my application. My learned senior friend has filed opposition to vacating. But we are filing opposition on behalf of respondent 5. 6
Yes.
is not yet ready.
Very well. You
So
file
Millard,
as-
we are filing,
You can file it, no issue.
Lordship. And in course of the day, Millard, we are going to serve a copy upon my learned senior friend.
You can file this in
Here and now, Millard, we are serving a
It
copy.
will be recorded.
So Millard, kindly Millard,
So, my lord, I shall file my reply to this opposition. Kindly grant me some time to file reply to this.
So Millard, kindly give us some protection so far as respondent 5 is concerned, because we are protected by the division bench order itself. Because I was already granted license. So I don't come within the purview of that. Kindly seize Millard the division bench order. We have handed over, Lordship. Kindly seize Millard paragraph 10 and 11.
Yes.
Order date is 6th August, Millard, 2024, Millard. Millard, para 10 says we direct none of the ration card holders shall be delinked from the dealers, and the dealers shall not be delinked from the distributors, if not already done, for a period of 2 weeks from date or until further orders, whichever is earlier. Para 11, if any delinking of ration card holders and or dealers has already been done, the same shall abide by the result of the appeal. So, in our case, appeal, license was granted on 10th August, 2023.
But dealers have not, the card has not yet been dealing. So, my lord, the ration cards which are presently tagged with me, that will remain tagged according to this order.
Yes.
Have not been dealing.
In our vacating application, you have stated it has been given to us.
License
Delete
is-
cards. Delete cards. Delete cards. After delinking from the dealers of my learned senior friend.
What is the state?
Weighing machine, everything, my lord, we have stated on oath in our vacating application, Lordship. Oh, my learned friend is for the state.
So I have to come with a fresh instruction because it's the old titles, my lord. What is the at present position, my lord? I will come. What is the present status?
And in my lord,
What is the status?
Present status.
He does not know about the present status.
On the private respondent or not?
Okay,
we are
okay,
still-
okay, submit the present status then. Submit the present status within a fortnight.
my lord, kindly, my lord, 1 week, Lordship, we are suffering. We have already been given, I am not on respondent
No, no.
6, my lord. And one more.
If they are ready to file within 1 week, I can.
No, one more thing, I'm sure even my learned friend in the writ petition has annexed one representation where he says he does not have any problem with me. That is respondent 5, but he has problem with 6. Kindly see me page 22, one representation, one page
That
22.
representation is now the
That will be the outcome of.
No, but my case is not within the ambit of that appeal because I have already been granted license.
license has been granted, but the cards have not been
If
given.
the ration cards
Have
was
not been
given to the respondent number 5,
And he has started from.
he shall carry on. No issue. That is the order.
Yes.
But status quo order, my lord, the authorities are misconstruing it, misunderstanding it, and they are
Let them submit a report. Let the submit a report. What is
The
the status?
clarification can be done by the division bench only. Whether
no. Ex
Because-
parte order, I am suffering over the coordinate bench of this honorable single judge presided over by Honorable Justice Patnaik. I am suffering ex parte.
Part of this order was single amendment. Justice Patna. That was challenging to this division bench.
I place the order. If already done.
প্রেজেন্ট স্ট্যাটাস কি আছে বলুন একটু জজ সাহেব জানছেন
You submit the present status. No, nothing.
Kindly give 1 week, Lordship. We are suffering a lot.
Whether 1 week it is possible for them to submit a report, otherwise again 1 week it will pass.
License এইটুকু up to us কিছু না যে whether we have been respondent 5 hasn't given license or not.
No.
I'm not a respondent.
It has been delinked or not. Let them.
Cards has been delinked or not, actually card has been given or not.
Acha, cards have been dealing all right, Lordship.
That is the issue. That is only
one issue.
That is the only issue. Very well, very well.
10 days.
Only in respect of 5. I don't want 6. Only 5, Lordship.
7 days.
In case of respondency, license has not been issued.
Sufficient. Very well.
Only in respect
Please
of
The issue of the dealing.
cards have been
Yes.
dealing in respect of
Very well,
added
very
respondent number 5 or not.
Affidavit in opposition on behalf of the added respondent number 5 is taken on record. Copy served. Full stop. The petitioner is at liberty to file the exception, comma, if any, comma, within a week.
It is reply, my lord, not exception.
Okay,
If it is
reply. Not exception. Reply. Full stop. Within a week. Learned counsel appearing on behalf of the respondent number 5 submits that the license was already granted to the
Only respondent 5,
number
Lord.
5. So, by virtue of direction of the division bench of this court in MAT 1543 of 2024 and others,
Everybody is admitting
the
that.
concerned authority is under obligation to allow the business of the respondent number 5 in respect of dealing cards. Delinked cards. Full stop. Learned counsel, Mr. Chatterjee, appearing on behalf of the state authority, submits that state authority seeks accommodation to submit a detailed status report regarding the dealing cards of the impugned FPS license. Full stop. Accordingly, the state authority is at liberty to file the report within a week. Let the matter appear in the list on 4th of September.
Deeply.
Milord,
Under the same heading.
Milord, he is given time 1 week, Lordship.
Yes.
Yes.
1 week, let him be 1 week. That means I cannot take up this matter on Friday, Thursday. That's why I'm taking this matter.
So, it will come under heading application, Lordship. It is under heading application today also.
No, today it is not under the heading of application.
Today it is under the heading application, Lordship.
Application আছে under the same heading. কিন্তু application কেন রেখেছেন? Can two words fixed to be the hard following with the appeal? Let it be fixed on same heading, so the matter can be taken up.
Lordship, may it be fixed, Milord, so that we can time 10:30.
Under the heading of application, it will be taken up. No issue. Wednesday, entire day I shall take up the matter.
Lord.
Monday, Tuesday, Wednesday, entire day I'm taking.
9 September, Lordship. 4th September.
4th of September.
Grateful.
For hearing group 8, item number 55 to 57.
Lordship, in item number 55 to 57, in item number 55, Mr. Surojitnath Mitra is appearing on behalf of the petitioner. In item number 56, Mr. Shara is appearing on behalf of the petitioner, and item number 57, Mr. Pathosarathi Bhattacharya is appearing on behalf of the petitioner, Your Lordship. Regarding item number 55, Mr. Mitra, learned senior advocate, has started his argument.
Yes.
But
hard in part.
I have been instructed by my learned senior that if Your Lordship kindly fix it 2 p.m. after 2 p.m. matters today.
Let it be passed over, my lord. What I understand, my lord, this matter is being heard by, I already indicated, my lord, that on 3 previous judges, my lord, couldn't be finished, my lord, or argument could not be concluded, my lord. Mr. Mitro submitted, my lord. Thereafter, Mr. Shahara and Mr. Bhattacharya will submit, my lord. It's already a fixed matter. Let it be. For the timing, it passed over.
As your lordship.
If the time accommodates, then after specially fixed.
দুটোই কিছু আছে আজকে? দুটো fixed আছে। 253. Okay, let it be pass over.
Yes, yes. my lord.
Let it be pass over.
Great. I am appealing for the petition, my lord. In this matter, my lord, I have concluded my submission, and oil company has started submission.
I am appearing for respondent number 2 and 3. I am praying for not today. My senior is currently outstation.
My lord,
What is the matter?
This is with regard to the grant of dealership. Retail outlet.
LPG dealership.
Retail outlet dealership, my lord. Petrol pump.
Petrol pump.
Petrol pump.
There is a population, whether that population of census of 2011 can be considered in the year 2024. That was my submission for us. When the advertisement has been issued in 2018, that cannot be done considering the population of 2011. That was my submission for us. And my lord, there was submission from their side of the oil company that one, the writ petition is not maintainable. The writ petition is identical to earlier writ petition, advocate's letter of oil company, and guideline of the national highway. These 5 submissions was made by him. Then after, my lord, since there was no time, so it could not be heard extensively. So let it be
What is
fixed.
your submission? What is the instruction? Not today.
Yes,
My lord, may I kindly fix it at 2 p.m. any day, subject to your lordship's approval, my lord, so that it can be heard. Yeah. Because it will not take more than 15-20 minutes. They just said.
কালকে কি আছে দুটো? কিছু আছে? দুটো কোনো ফিক্স নেই তো? Tomorrow can it be fixed at 2 p.m?
Yes, I have no objection.
Tomorrow. Okay. আছে? Tomorrow not possible.
Any day, my lord.
দেখুন তো এটা দেখুন। Next.
Any day whenever 2 p.m. is.
Next.
কোনো দিন হলে।
হবে না? 28 তারিখ দেখুন। তাহলে 28 তারিখে রাখুন। 28th 2 p.m. as a second matter. I have already fixed and one matter. Thereafter this matter.
My lord. 28th.
An accommodation is sought for on behalf of the petitioner, on behalf of the respondent. Accordingly, the matter is adjourned today. Full stop. The matter is heard in part. Accordingly, the matter will be fixed for further hearing on 28th of August 2024 at 2 p.m.
Deeply obliged.
Obligement.
In this matter, my lord, I have already concluded my submission, and Mr. Chatterjee was continuing. Probably he has also completed his submission. কি ছিল? No, my lord, I am sorry, my lord.
I'm not in the matter, man.
Oh, well, I am sorry, my lord. State was supposed to make submission. I have concluded my submission. But today he is also not.
Who is appearing for the state authorities?
My lord, according to
Mr. Indranil Roy,
Tapas Kumar Mandal, Mr. Indranil Roy. Well, let it be fixed on that same day at 2 p.m. I shall take chance on that day, 28th.
Okay.
এটা এমনি রেখে দিন 28 তারিখ 2টোর সময় 3টে হল
My lord, 28 at 2 p.m.
28. After your first,
Yes.
after
My
your
lord
that
will kindly
matter-
pass an order, otherwise it will be difficult for him.
Okay, please take down.
And my lord, let there be know that I shall serve the notice upon.
None appears on behalf of the respondent authority. The matter is heard in part. Full stop. The petitioner has concluded his submission. State authority supposed to argue today. Considering the situation, the petitioner is directed to serve a notice upon the learned counsel appearing on behalf of the state, informing that the matter shall appear in the list on 28th of August 2024 at 2 p.m. as a specially fixed matter.
Deeply, my lord. Deeply.
Yes, my lord, in this matter, I am appearing on behalf of the respondent.
My lord,
Just a minute. The petitioner has concluded his argument. This is
Yes.
also a part heard matter, my lord. May I start, my lord? Today,
Yes, yes.
may not complete, but very well. The fact is this. কি বলছি বলে না? তুমি যদি তোমার সাবমিশন থাকে you place the submission. The peculiarity is this, my lord, just for example, I mean, before turning into the documents annexed with the writ petition, your lordship knows that in the event for the purpose of selection of LPG distributorship, an applicant is required to place the necessary documents around the informations regarding, at the very first instance, the application should contain the land over which he wants to construct his godown and the showroom. The peculiarity of this, that the person concerned offered 2 plots of land, for example, A and B. According to the procedure that he became the successful candidate by due course of draw of lots, his land offered by him, that is A and B, was physically verified, that is called field verification, that was approved. Letter of intent was issued. I will come. Letter of intent means you have to perform certain formalities before commissioning. Now, thereafter, and also the licenses from the appropriate authorities, that is the local authorities as well as the explosives department, petroleum and explosives department. Now he applied. I will show that with different plots. First, one plot, say A and B, out of those 2 plots, he applied first B and C, thereafter A, B, C, and thereafter A, B, C, D.
Regarding approach road.
Not approach road. That is the construction of the godown.
Yes.
Approach road is something different. That is not the facts pleaded in the writ petition. Now, I have allowed them to construct A and B, over which the godown is to be concluded. The guideline shows or specifies that you will have to perform or observe or follow the local laws. That means that the land has to be converted. Classification of the land has to be converted. Now, and the most surprising thing, all these things, that is application before the appropriate authorities for the licenses was done without putting into my notice.
That means explosive department
Yes.
and everything.
And the godown has been constructed over all the 4 plots. Now, what the procedure says? Procedure says very well, you are entitled to offer an alternative land. But first, you have to offer, and I will have the opportunity to consider. Unless that is considered and approved, then the FVC process through which he has obtained the LOI becomes redundant, ineffective. I have verified the land and approved. Now, after approval, 2 plots, you have unilaterally added 2 more plots without putting me into notice, constructed a godown, that too without conversion of a particular plot over which we have already constructed the godown.
What Rocio say?
Rocio
After issuing of LOI, the applicant can offer 2 or 3 more separate plots.
Yes. But for
the purpose of better.
That is called alternative plot of land.
Alternative plot of lands. But,
Now, for
but he has not opted.
Unilaterally, he himself added plots or changed the plots. He
Without
has to-
any application to the authority.
No. Subsequent to.
Okay. After creation of the whole structure.
Yes. And that is admitted. And the land has till date over which, and he has not just said that I will not utilize that particular plot of land which has not been converted. As a matter of fact, he has admitted in his email as well as the documents that he have constructed godown over that land. Now, how can I allow to perpetuate an illegality? Conversion of land without obtaining necessary sanction from the DLLRO.
Order of conversion.
Yes, that has to be done. Time was given. That was not done. Now, the foremost thing before making any observation with regard to or interfering with the writ petition, your lordship, or passing any order with regard to the writ petition, your lordship has to be satisfied that whether we have acted arbitrarily, whether the guideline, we have acted contrary to the guidelines, whether we have acted malafide or in violation of the principles of natural justice.
Yes.
And these are all the settled principles of law. And what is the interpretation of the tender documents? And the person concerned who have invited the applications for the dealership and the documents, the contents of the tender, I am the best person to clarify. And that has been settled from the Dayaram Shetty's order, very old.
Yes.
Thereafter, subsequently followed by Afghan's judgment as well as Cartel's judgments. I will refer to that. Now, my humble submission before your lordship is this: one by one, I will be placing what he has done, my lord. First, your lordship turns to.
Now, today, I think we have crossed the time.
In that event, since your lordship has already fixed 3 matters, apart from already fixed. So, if your lordship pleases, I can make my submission tomorrow morning, my lord.
Let me proceed with those matters first. If time permits, I will take up these matters. Yeah, today.
Very well, very well.
I will take up this matter today so that we can continue tomorrow.
Very well.
Okay.
My lord, may I submit what you have? Mr. Prosenjit Mukherjee is appearing for the petitioner, my lord. He is not present today in the court, my lord. In that case, my lord, kindly take it up tomorrow, my lord, so he can reply after he's finished.
Yes, yes. Let him finish first.
আচ্ছা, তো পরে আমি ওটা করে দেবো, একটু থাকবেন।
Call the matter. Two PM matter.
Ram for petition. 52. 52 though.
Yes, ma'am.
I'm filing my reply to the opposition filed by the private respondent.
I am for the statement.
My lordship, I am praying for not to desist because my senior, he received an emergency call from his home, so he rushed in.
Point of maintainability was raised.
Well,
Point of maintainability was raised. This is
The
the
morning
only issue
session,
to
my
be
learned
decided.
friend was
So,
there.
you are appearing respondent.
Yes, my
I don't
lordship.
know how many times. I cannot say something, but this for possibly my lord 13th or 14th occasion adjournment is being prayed for.
Whatever may be. This is your reply. Tomorrow,
My lordship, kindly keep it on Thursday.
Thursday, Friday, I cannot take them. Group 6 matters are there for Thursday and Friday.
Tomorrow 2 p.m.
My lordship, he has some difficulty tomorrow. My lordship, kindly keep it on
Then
any other day except tomorrow.
then it will be on Tuesday.
Next.
2 p.m.
Okay. An accommodation is short for on behalf of the respondent, private respondent. Let the matter appear in the list on
বাড়ি থেকে
27 at 2 p.m.
As Pathar matter.
as a part of matter.
Get to.
Affidavit in reply file on behalf of the read petitioner to the affidavit in opposition filed by the respondent number 6 is taken on record. ওইটা আগে লিখে দেবে হ্যাঁ এফিডেভিটটা next
Okay, good.
My lord, I beg to appear for the petitioner, my lord. My lord,
I am appearing.
Mr. Bashu was submitting, my lord. Today we
Yes,
need
yes.
well, my lord.
My lord, I am blood for respondent number 7. I personally told your lordship that I can do it today, but I need one more day's time at least because I could not complete my research within this time. So I would request blood if the learned advocate for the state wants to complete his submissions today, I don't have any difficulty. But so far as my work is concerned, that is replying to the judgment cited by the petitioner and placing a few
no, Mr.
judgments.
Basu, as you have already started, you have
My
to
lord,
conclude it.
Of course, in that case, blood, kindly take it up any other day, subject to excepting Friday. Excepting Friday.
That is another issue, but you have to conclude it first, thereafter state.
Very well, very well. I don't have any difficulty either.
Next Wednesday?
Next Wednesday. I'm grateful.
Okay.
And subject to your
My lord.
lordship, subject to your lordship agreeing, blood, I can use a short written note also.
No,
One
issue.
or
You
two
can.
pages.
Okay, okay. Please
I'm
take down
Grateful.
the matter hard in part. Let the matter fixed on 28th at 2 p.m. as a part of matter.
Very good. I'm grateful.
পরের বুধবার অসুবিধা কি তাহলে 28 অসুবিধা নেই তো My lord, only one indulges every matter be at the top, my lord, so that my lord can take up the matter at first, my lord. Because
Issue is that
already my lord is listening to the matter.
I have already fixed some matters at 2 p.m.
My lord,
There are the 2 p.m. matters. I have 2 part-out matters
my lord,
already fixed at 2 p.m.
my lord, my lord. Grateful lordship,
I
grateful.
do not know whether that would be done or not.
My lord,
If not
grateful
done,
lordship. Today both the 2 p.m. matters are
the
adjourned
two-
today.
no, I have another certain other matters also, part-out matters.
Grateful lordship.
Grateful.
দিয়েছিস না নাম দিয়ে দে আমার নাম দাদার নাম
Yes.
আমার অসুবিধা নেই, কিন্তু সুরজিৎ তো কন্টিনিউ করছে। Your Lordship may remember there are 3 matters,
Yes,
but so far the first item is concerned Mr. Surojit Mitra started his argument. He could not conclude his submission on last occasion,
no, he has not concluded.
my lord. So unless he concluded, possibly
Where is his advocate on record? The morning
I've been
also.
told, my lord, Mr. Mitra is stuck in court number 35, 38 court number.
So what can be done?
Tomorrow?
Not today.
Let off. Because, my lord, unless it starts, the ball starts rolling, my lord, it will not complete.
No, absolutely, he is correct, my lord. This matter was heard number of occasion by the other
No,
coordinator.
not today. Tomorrow at the same position.
Yes, madam.
চলবে এই চলবে
একটু চলবে
আবশ্যক আছে
ওই তো আছে ওদের তো শেষ হয়ে গেছে হ্যাঁ Now, my lord, before proceeding further, my lord, may I hand over the list of dates, my lord? Now, my lord, first, the advertisement is also already there at page 24. I need not travel into that advertisement. But first thing is the application, which is at page 28, my lord. That was filed on 18th of October 2017 of the writ petition.
Page 28.
Yes, my lord.
Yes.
The page 29 contains the description of the land offered by the petitioner. Your lordship will find the tabular form appendix 2, the first tabular form in the top, that is, here your lordship will find that the dag number 4255 and 4256.
Yes.
First, second, third, fourth, fifth column. Khatiyan number, survey number, that is the two dag numbers has been specified 4255 and 4256.
Yes.
Now, what I was submitting, that these are the two dag numbers with regard to which field verification was conducted after he was declared to be the successful candidate and letter of intent was issued.
Yes.
Now, your lordship comes to page 47 of the writ petition. Page 47 is the letter of intent. It was issued on 11th of August 2018.
Letter of intent.
Yes, my lord. That is also there in my list of dates. Of 11th of August 2018.
Yes.
Why I place the contents of the letter of intent. First, serial number 1, third paragraph. The construction of godown and showroom in the letter of intent.
Yes.
The construction of godown and showroom should be completed within a period of 4 months from the date of this letter. both godown and showroom should be freely accessible through all weather motorable approach road.
Yes.
Why I place this? Because to show that the letter of intent provided a specific time period for completion of the construction.
Within period of 4 months.
4 months. Thereafter, page 48 also commissioning, that is, make all out efforts to commission the LPG distributorship within 4 months from the date of this letter.
Yes.
Clause 5.2 specifically provides, if we find that the progress being made by you towards the above is not to our satisfaction, this offer is liable to be withdrawn. Yes, my lord. And thereafter it is further reiterated in clause 9, that is at page 49. This letter is merely a letter of intent and is not to be construed as a firm offer of LPG distributorship to you. If we find that the progress being made by you towards the above is not to our satisfaction, this letter is liable to be withdrawn along with forfeiture of amount deposited by you with the corporation before FVC.
Yes.
Now your lordship comes to page 79, my lord. From here it starts how he misrepresented the authorities, statutory authorities for obtaining the licenses. That is page 79, which shows that the letter was issued on 27th of September 2018. Your lordship kindly notes the date. Letter of intent on 11th of August 2018. Thereafter, on 7th of September 2018, he applies before PESO. Wherefrom it appears the subject. This is issued by the Government of India, PESO organization, Petroleum and Safety Organization. Proposed storage of LPG gas in cylinders at plot numbers RS 3521, LR 4253, RS 3531, LR 4265, RS 3532, LR 4255. So how many plots? Your lordship will find there are 3 plots. Initial application, 2 plots. Which were they? Just for reappreciating, your lordship kindly comes to the application. Your lordship will find that the plots were
4255, 4256.
Yes. Now, apart from 4255 and 4256, he has added 4253. So whether it is a misrepresentation, we have allowed you to construct your godown or get sanction over 4255 and 4256, which you placed before the authorities for field verification. And nothing is on the record that prior to this application, before the authority concerned for license, fire license or petroleum safety license, explosive license, my lord, he applied before the authorities, the IOCL authority, for having this particular plot of land to be added or as an alternative plot of land. That was not done. Admittedly.
What is the procedure for appearing or approaching PESO after the LOI?
Yes, he will have to get the licenses, and the license.
No, licenses through the.
No, he will have to apply
direct.
For the license. Yes.
Not
We
through
will,
the not through the oil company. Directly to the PESO.
Yes, my lord. Since your lordship will find that the application, this particular letter has been issued on behalf of Bapi Haldar, proprietor of Jhilli Indian Gramin at the top, he applied for, and the authority concerned has also replied to the same to the petitioner.
Yes.
It is not that we will apply and for his license.
Or I think it was whether it was forwarded through the
No,
oil company or
we
not.
can ask that please consider it, but it is not that we will have to confirm that whether he has satisfied the necessary conditions for obtaining the license. They have the separate rules. Explosive license,
Yes.
for which the person concerned have to apply for obtaining the license.
Directly to the PESO.
Yes.
Okay.
Now, these are the particular plots. It is not a case, even in the pleadings, or not a case, as a matter of fact, that has to be routed through IOCL or the oil companies. It is always done, and in the event your lordship desires that I will have to place what is the rule, then I will have to obviously find out and place before your lordship. I will. Now, that please refer to your application number such dated 22 September 2018. Contents, I am coming one by one.
Yes.
The site layout and construction plan of the proposed storage facilities is approved, and 2 copies of each of the same is returned herewith duly signed in token of approval. So he has placed as a token of approval, this was given. Conditions for approval: undertaking stating that all necessary clearances from revenue, fire, local administration, etc. have been obtained, and the construction of the premises has been completed as per approved plan, complying with all relevant requirement under these rules. So local administration, clearance from local administration is one of the condition precedent for this license. Now, thereafter, after last paragraph, after completion of the construction of the storage shed in every respect as per the approved drawing. Obviously, the drawing consisted these 3 plots. He placed the drawing on the basis of these 3 plots. Apart from the earlier 2 plots, he added another plot.
Yes.
And placed the plan that was approved. And without putting the same into the knowledge of IOCL. He is merely a licensee, have to think, and tender conditions has to be followed. You are requested to forward the following documents as required under gas cylinders rules for grant of license in form of such and such. That is different. Yes. Thereafter, your lordship comes to the next page, page 80.
Yes.
Here your lordship will find this is from Khargram Panchayat Samiti, 15/11/2019. What I find, Khargram Panchayat Samiti. And your lordship will find that comprising of plot numbers 4253, 4256. 4255 has been completely omitted. Initial application 4255.
This is license carrying offensive dangerous trade by the executive officer Kharda Gram Panchayat Samiti.
Yes.
Panchayat Samiti license.
License under license renewed under the same terms and conditions, whatever be that they have placed this document. What I just want to place before your lordship, how they misplaced the facts, made misrepresentation that this was not the plot numbers which we approved.
4253, 4256.
Kindly see is that we have approved some plots, and skipping one plot, whether in his own volition he can add some plots and conduct, then where is the discipline? What is the use of our guidelines? What is the use of our verification of the field verification? So 4253, 4256, completely omitting 4255.
Yes.
It was incorporated in the application. Now your lordship kindly comes to page 82. Department of Food and Supplies, license from this authority is also required. Here also your lordship will find the licensee shall carry on aforesaid business and store cylinders of cooking gas only at the following places. That is 4253, 4256, Putiam 4385. 4255 has been completely omitted. Apart from that, there are several annexures one by one. Page 72, my lord. This was issued on 28th of March 2019 by Office of the District Magistrate, possibly. It's not legible, West Bengal and West Bengal Fire and Emergency Services. The signature contains Director in Charge, West Bengal Fire and Emergency Services. Here also you will find, your lordship will find
Demand notice.
Yes.
Demand notice.
Yes, demand notice for some documents as well as the fees he has to place for the license. A required amount is to be deposited before the authority is concerned, and that has been demanded. What I want to indicate is that here also he has specified 4253 and 4256 for the license. That is sub demand notice under last line in the subject column row 4253 and 4256 last line.
Yes.
So what I want to indicate is that before fire authorities also, he has suppressed the fact that he is not going to make any construction or want to get any license with regard to 4255. Now, troubling your lordship again on page 69, my lord. This is the Government of West Bengal Office of the Director General of West Bengal Fire and Emergency Services. Even here, in the subject, the portion at the top specifying the subject, your lordship will find that the name and style of Messrs. Jhilli Indian Gramin Vitarak at Muja Jhilli, jail number such, plot number 4253 and 4256. 4255 omitted. Now, here contains, I am returning here with copy of the plan duly signed and approved by this department. So obviously the plan was placed with regard to those two plots, and he just made misrepresentation before the authority concerned and got the same signed and approved. Now, recommendation portion first. The construction and layout shall be as per approved plan and shall not be altered in any way. These are the undertakings. The license premises shall never be used for any purpose other than storing. I will place before your lordship from his own statement that he has made construction over 4 plots of land, not only these 2. He has admitted, he has stated that I have constructed over 4 plots of land, including 4255.
Yes.
Yes, madam. Now your lordship comes to page 96, which probably has been placed by the petitioner to contend that this is the approval. Page 96. It's a letter written by one sales officer while inspecting the godown. What it contains, this was issued on April 22, 2019. That post facto, the licenses applied for and received, your lordship will find all prior to April 2019. What I have just shown, March, February, etc. Now here shown says that completion of LPG godown construction of Jhili Indian Service. What was written? This is to inform you that LPG godown construction for Jhili Indian Gramin Vitrak has been completed at plot number 3529, LR 4253, RS 3531, LR 4255, RS 3532, LR 4256, Khatia number such and such. You are requested to kindly carry out final inspection of the said godown and grant the final explosive license to Jhili Indian Gramin Vitrak to expedite the early commissioning of the Indian distributorship.
This is a letter written by
sales officer,
one of the sales officer of LPG.
Yes. Whether now contention, their contention, this is an approval. Whether this particular document or letter can be construed to be an approval of all those. Now, what is the procedure to be followed for an alternative land, an additional land?
Yes.
I am clear, my lord. Initially, 2 plots were given. By placing this document, petitioner contends that 2 fresh plots has been incorporated, should be considered to be an additional plot. Now, there are 2 distinctions between additional plots and alternative plot. What is alternative plot? Need not explain that in lieu of this plot, I am offering this plot. Additional, keeping this intact, and they have admitted, I am offering 2 other plots.
More 2 plots.
Yes, to accommodate the entire thing. Now, this was the letter issued by the officer concerned. It neither proves that there was an offer nor acceptance. It was merely an application or request before the Chief Controller of Explosives to inspect and get it done. I will come into that.
Yes.
Now, the next page.
Yes.
Next page, your lordship will find an application by the petitioner before the sales officer. Your lordship kindly sees the date, 9th of December 2020. We issued the letter of intent during 2018. All applications, what I have showed to your lordship, pertains to the year 2019 or 18. And the fag end of 2020, he places an application alternate land for godown Jhili. Now, whether it is really an alternate land, your lordship kindly comes to the contents. Nomenclature does not mean anything. I, Bapi Haldar, proprietor of Jhili Indian Gramin Vitrak, is facing difficulties against the proposed land for godown, which created some unavoidable circumstance, forcing me to propose addition of land. Here comes the truth.
Yes.
I therefore would like to propose addition of different plot to the initial proposed land for better convenience and connectivity, and have received verbal confirmation with competent authorities stating that there will be no problem in addition. What are these? Verbal. Now, the kindly sees that in the event he says that the earlier letter issued by the sales officer is an approval, then what was the use of writing this letter after a year? Had it been considered the earlier letter of April 2019 is an approval of the sales officer, just page 96.
Yes.
that it is an approval, and you gave approval with these 4 plots. Then why did he write this letter for an approval? It's a contradictory statement. He understood that there was no approval, for which he stated that.
Yes.
Your Lordship kindly comes to page 100. In the record of rights, 2 plots, 4253, 4256.
Four two five three is the Danga.
Very well. Classification I will come later on. They have converted, but maybe converted, and they have placed 4253, 4256.
Yes.
There were supposed to be 4 plots with classification. Nothing is there. Even my lord, they are required to get insurance. Even in this respect, also, they have misrepresentation at page 104. Before the New India Assurance Company, they got the insurance with regard to the godown in respect of plot number 4253, 4256. Page number 104. Details of asset covered under the policy, location, such, plot number 4253, 4256. So in any event, if an accident happens, he will not be able to get the recover the damages from the insurance company. This is a wrong statement, erroneous statement. I will show that whether he has constructed over all the floor plots. That is the admission. I will come.
Yes.
Your Lordship kindly comes to page 108. That will clear one by one. 100, the letter to DGM LPG Sales, Durgapur Area Office, City Center, Durgapur. Yes, page 108. So this is the first time a management has been informed, IOC has been informed that he wants to alternate land. Now, whatever is there in the first page, your Lordship is the same. Your Lordship kindly comes to page 109, 3rd paragraph.
Yes.
Sir, I have another 2 lands. Kindly follows the language. I have another 2 lands beside the old proposed land of godown. One of land, plot number 3529, such and such, which already converted for godown, is owned by me, and another land, RS plot number 3534, LR plot number such, has been leased by me from my friend Devashish Bishar. Conversion for leased land is underway, and very soon conversion will be completed. I want to propose these lands for godown. So here comes additional lands to be utilized for godown. And the date your Lordship kindly sees, 15th of January 2021.
Yes.
The last paragraph says, sir, I humbly request you to give permission for new land. So, admittedly, he was conscious of the fact that approval was not given for new land. That is the land other than what was specified in the application. Otherwise, I have to hang myself. These are the contents. Now, your lordship kindly comes to the show cause notice at 110 and his reply. Now, why I place this will show whether we acted arbitrarily without any reason, or this show cause whether we have given an opportunity to justify his position, to follow the principles of natural justice.
Yes.
Since the basic, for the purpose of tender process, I have to satisfy that I have not acted arbitrarily, mala fide, or in violation of the principles of natural justice. So unless it is proved that the guidelines has been violated, or I have acted contrary to the procedure laid down in the selection procedure, there cannot be any arbitrariness. First, this has reference to our LOI dated such, LOI number such, dated 11/8/2018, placed on you for setting up Gramin Vitrak distributorship, and subsequent letter by mail dated 17th of August 2020 regarding unsatisfactory progress by concerned field officer of the corporation after visiting the godown construction site on 16th of October 2020. I will place those documents. It is with our affidavit in opposition. During the visit of the concerned field officer on 16th of October 2021, it was found that the construction of godown was done on plot number 4253, 4254, 4255, 4256. However, the field verification committee was conducted only on plot number 4255, 4256, which implies that you have added 2 more plots for construction of the godown without any prior approval from the competent authority.
Yes.
Your lordship will have to see whether they have denied and disputed this particular content, intention, that they have not informed us in their reply whether they have denied that. Further, to the above, it was also found that you have stated LPG godown construction without land conversion certificate of the above mentioned plots. You have also obtained PESO license for storage of LPG cylinders to the above mentioned godown, but while checking the PESO license, it is found that only 2 plots are mentioned in the PESO license, that is plot number 4253, 4256. It is pertinent to mention that plot number 4253 and 4256 are not continuous plot as per Mauja map submitted by the concerned field officer. Therefore, after assessing all the irregularities, the concerned field officer had sent you mail on 17th of October 2020, comprising of all the irregularities, and asked you to complete the LPG commissioning formalities at the earliest, as the LOI was pending for more than 4 months.
Yes.
Upon many follow-ups, you sent a letter on 15th of January 2021, wherein you have accepted that the godown land is not correct and it was your mistake to construct the godown on the wrong plot of land. By same letter, you have asked for approval of alternate land for construction of godown. The plot bearing Khatian number 6385, RS plot number 3529, LR plot number 4253, and another plot of land bearing Khatian number such, RS plot number 3534, LR plot number 4258. The plot is leased by you. As per your application dated 15/1/2021, the concerned field officer visited your godown site once again to inspect these 2 plots and found that the construction of godown has already done on new plot numbers 3534, and only 5 meter has been included in godown plot number. I can't read my lord, RS plot number such. Land declaration made in your application, that is RS such and such and such. No prior approval was taken for godown construction on plot number 3534. Also, no land conversion certificate is available for RS plot numbers 3534 at the time of visit of the concerned field officer. While cross-verifying, next page, my lord, 111, while cross-verifying plot number 3534 with government data, it was found that there is no record of this land in the government site as well. Therefore, no approval for alternative land was issued to you and asked to correct the mistake at the earliest and complete the commissioning formalities without even further delay. However, you did not reply to the area officer till date. Neither you have submitted corrected peso license, nor you have submitted the conversion certificate of the new proposed alternate land, that is plot number RS 3534. As you are aware that the scheduled time given in the LOI for commissioning of the distributorship was 4 months from the date of issuance of LOI, even after lapse of more than 2.5 years from the date of LOI, you have not made any significant progress towards commissioning of the distributorship at location Jhilli. Therefore, you are advised to submit reasons as to why LOI placed on you should not be withdrawn as per clause 1, 5.1, such and such, on account of unsatisfactory progress in commissioning activities. Your reply must reach us within 5 days on receipt of this letter.
Yes.
Now, the same letter has been annexed on which was issued on 15/1/21. That is the next annexure. Thereafter, your lordship comes to 116. That is the email which was issued by one of the officials of the IOCL, competent officer, on March 10, 2022.
Yes.
To the petitioner. Your lordship kindly comes to the 3rd paragraph from the top.
After issuance of show cause.
Yes. After issuance of show cause letter, you have replied by trailing mail dated such, that too after so many follow-ups, and even a subsequent reply by letter dated 17/2022. In both the replies through mail and letter, you have confirmed that your land conversion is still pending for plot number 4255. So what I indicated at the very beginning of my submission, initially 2 plots, 4 plots, and when we come just coming short, we find that 4255, which was initially offered in the application, was not converted. I will show from his own statement that he has constructed the go down over all the plots. His own submission. It is pertinent to mention that you have constructed go down on plot number 4255. Next paragraph. Without land conversion. You have, lordship,
Yes.
got it. Without land conversion, approval, which is one of the major violation of statutory norms. Initially, LOI approval was given on plot number 4255, 4256 after thoroughly field verification. But during field visit of the concerned field officer, it was found that 2 extra plots, 4253, 4254, have been added with the above tag, and go down has been constructed without any approval from the competent authority of the corporation. Also, the sale deed against tag number 4253, 4254 are 7/9/2018 and 4/9/2020 respectively, which is after the date of submission of the application.
Last date of submission of application.
Yes, my lord, that has to be distinguished. After LOI, if it is a new land, alternative land, new land, he can have a fresh land. That is maybe a newly purchased land. That is after LOI. But here it is a case, it is not a new land on the basis of alternative land. It is an additional land. So, in the event he wants to get this advantage during field verification stage, not at LOI stage. Field verification is the first stage where he also have an opportunity to offer alternative land, but that should confirm that the lease is or the purchase is prior to the last date. But at the LOI stage, the land can be post last date.
Okay.
After last date. That
after the date of LOI.
Yes. So, since it is an additional plot of land, he cannot take benefit of LOI. This is an additional plot. Apart from that, this is one of the most significant point has to be gone into by your lordship, that whether by making the word alternative, he can change the nature. Alternative land against this plot, this plot. Now he is not contending that, he is adding something, keeping the other plots intact. Anyway. Now the last is the termination letter, which is under challenge. I am not aware of whether this has been placed, since everything has been clearly specified in this termination letter, that where and how he violated the provisions.
2nd of May.
2nd of May 2022.
Page
I will not
118.
trouble you. Yes,
Page 118.
yes, starts from 118, but I will not trouble your lordship to travel into the entire documents, since it is the same one. I will just indicate page 119, starting from paragraph 3, third paragraph.
Yes.
As mentioned above, it was already found that you have constructed godown on plot number 4253 without prior approval, and after construction, you have submitted the same plot of land for approval as alternate land, that too after it was pointed out by the concerned field officer. Also, the sale deed for plot number 4253 was executed after the last date of submission of the application. Since the construction of godown was already completed on plot number 4253 without any approval, it was unethical to approve the alternate land in line with the policy. Also, for other plot number 4258, approval was not given because the conversion of the land was still pending at the time of application and LOI date was already at expiry stage. Next paragraph. Thereafter, you were asked to report to DGP IDO along with all commissioning documents in order to commission the LPG distributorship at location Jhilli, Murshidabad. You have reported at DGP IDO and submitted that the land conversion is still pending for plot number 4255, where godown construction is already completed, which is major violation and illegal as per the government rule. During the visit, you failed to submit commissioning documents at DGP IDO. Therefore, a show cause notice was issued on such and such date against unsatisfactory progress in LPG distributorship, commissioning activities, and why 2 extra plot number 4253, 4254 added in godown construction without even taking prior approval from the corporation. You replied to your letter by email dated 1st of February 2022 and stated that plot number 4255 land conversion certificate is used to be obtained, but did not explain on 2 added extra plot in godown conversion. The reply was found unsatisfactory as the status of the LOI is still same as it was a year ago, and therefore, within bracket, land conversion certificate for plot number 4255 is still pending. A mail was sent to you on 10th of March 2022, stated that commission must be completed within 7 days as LOI is more than 2.5 years old and corporation cannot wait for the land conversion to be obtained by you indefinitely. Subsequently replied to the above mail with the same line. He had replied earlier that land conversion certificate 4255 is still pending. Now, concluding this, the authorities held, in view of the above, your candidature is rejected by the competent authority in line with terms and conditions of the LOI as per the above mentioned clause, advertisement, brochure, and policy of the corporation. The FVC fees submitted before the FVC will be forfeited as per policy decision. So this was the termination. Now, against this writ petition, I have already submitted the affidavit in opposition, my lord. Placed before your lordship, the affidavit in opposition. Now, before, very well.
What is the reply to the show cause?
Yes, my lord. I will come since he
Okay.
has not annexed.
Okay.
I will come. That has been annexed with the
AO.
Yes, my lord. Now, before going into that, I will just indicate what is the provision for alternative land and at the FVC stage as well as alternate at the LOI stage. That is my affidavit in opposition.
Yes.
Yes, my lord. At page, yes, 22, 26, my lord. Internal page 6 of 47, 26. That is clause 2, basic facilities required for operation of LPG distributorship.
Yes. Yes, proceed.
If the land offered by the candidate in the application or alternative land offered by the candidate at the time of field verification meets all specifications as laid down in the advertisement on the basis of which LOI has been issued, then LOI holder can offer an alternative new land for construction of godown of specified dimensions in the advertisement location, which will be considered on the grounds of such and such. This is at the LOI stage, he can offer a new land. Now, your lordship kindly comes again to the first lines. If the land offered by the candidate in the application of alternative land offered by the candidate at the time of field verification meets all specifications. So, at the application and an alternative land at the FVC stage. So, during FVC also, he has an opportunity to provide an alternative land. But that land has to confirm the eligibility criterion so far as that the land should be purchased or leased prior to the last
date of submission of application.
Now, after the completion of FVC, when the LOI is issued, he will have a further opportunity. And in that case, for this particular purpose, for the enhanced security, safety, better, etc., he will be entitled to provide a new land, which new land need not qualify to satisfy that the land should be prior purchase.
I understand.
So in this case, why it is relevant that he has not applied for alternative land? It's an additional land. So during FVC ought to have been placed.
Oh, he has not applied for additional land also.
He unilaterally added.
Yes.
Just a moment, my lord. I will show that he will have to satisfy all the government regulations. That is at page 31, my lord.
Yes.
That is middle portion, it will be starts from. So it will be the responsibility of the selected candidate to observe and perform the provisions of all rules and regulations. That is the answer what your lordship placed before me. The license, rules and regulations, government or municipal or local acts, laws, regulations, bylaws as may be enforced from time to time with respect to land for construction of the LPG godown. Why I indicate that? That without getting a conversion of the classification, that is the local laws, municipal government acts and bylaws, whatever.
This is come under the common eligible criteria.
Yes.
Page 29.
I cannot follow you, my lord.
Page 29.
Page 29. This is under eligibility criteria,
Criteria
for
for application.
Clause 8. It
Yes.
starts from page 29 and this is under this heading.
Yes.
Now your lordship comes to page 53, 53 of my opposition. That is the letter which I have already placed. That was annexed with the writ petition.
This is the mail. This is the
Yes,
mail.
10th of March 2022.
Yes.
53. This I have already placed before your lordship. Next page, that is page 54. This finds reference in the letter of termination also. This was the communication made by Bapi Haldar through email on 1st of February 2022. This is very important, my lord. On 22 itself, he says that yet to be converted. And subsequently, but what he says here. With respect, I, Bapi Haldar, son of such and such, hereby want to inform you that as a part of commissioning Jhili Indian Gramin Vitarak, we have completed conversion of plot number 4258, which comes under our godown land. So, sir, please check the under attached document of that conversion and allow me to apply for peso for the same land. Thereafter, next page.
No, in reply in the said mail, in reply of the 10th March mail, no. Page 53 is the mail of 10th March 2022.
Show cause, where is the, your lordship is wanting to get the reply to the show cause.
Yes. No, I want to say the page 54 is a letter of Bapi Haldar. That is 1st February 2022. Thereafter, the letter was written by Pramod Kumar.
Yes.
53. That you are saying that it was not converted.
Yes.
Still pending.
Yes. Your lordship kindly comes to page, will clarify, further clarify, page 55. That is of 14th March 22. Page 55.
14th March 2000.
This is subject reply against show cause letter dated 10th of March 2022. That is
10th of March.
Yes, 53 was the letter what I have placed before your lordship.
Yes.
And this is the reply from which it will appear, entire thing.
Yes.
With due respect, I, Bapi Haldar, son of such, want to inform you that I am trying my best to do the conversion of the proposed land LPG godown. But unfortunately, there is unnecessary delay from the Block Land and Land Resources Office. Conversion of LR 4258 has completed and LR 4255 is underway. After getting approval from PLLRO, I will go for PSO and fire license. So even on 14th March 2022, 4255 was not converted. Any query false, I can satisfy.
Okay. No, where is the answer to the show cause?
He says this is the answer.
This is the answer.
This is reply against show cause letter dated such. My lord,
No, show cause letter dated 17th of February. Your show cause. Where is the reply? Page 110 of the writ petition is your show cause.
that is not my writ petition, that is their writ petition,
Yes.
but they have not annexed the reply. Possibly that was sent through email. And your lordship will find just after page 116, I have a blank page, my lord. Possibly that was reply against states. I don't know whether that forms part of your lordship's file. 116 is the progress letter, and thereafter another letter is there.
No, 116 is the mail of Pramod Kumar.
Yes, my lord. Thereafter,
March 10.
Yes, that is also in my opposition.
Yes, it is
But,
your but where
this
is the
particular
show cause?
portion 17 is completely blank in my.
Yes, 17th February, 17th December 2021.
Now, my lord, at page 58, this is the site plan submitted by the petitioner himself. I will try to get the reply, my lord. That is, just now I cannot find it from the two documents. Like that. Now, my lord, show cause was issued on 17th of December 21.
Yes.
And thereafter, your lordship will find the next, that is at page 54. That is the next communication we have received. That is my AO 54.
Yes, 54 is the letter of the Vapi.
This is the reply.
1st February.
This is the letter we have received. And that I have stated in my affidavit in opposition also, I will indicate. They, what they ought to have been done, they have not done. They have replied to the same. And 17th of February 2022.
Now, your letter, your mail at mail
17th of February.
No, your mail at 10th March, page 53.
Yes. Was replied to. Was replied to.
This is your communication to the Bapi Haldar.
Yes, and Bapi Haldar in page 55 replied to the same.
Yes.
Page 55. But so far as what your lordships stated that fell from your lordship, that is on 17th of December 2021, we issued the show cause notice, and what is the reply on behalf of the petitioner?
You read the second paragraph of page 53, your AO.
Yes. Against the unsatisfactory progress in commissioning of LPG distributorship at location Jilli, a show cause letter was issued by reference number such dated 17/12/21 to you, and the same was received by you during one-to-one interaction during 17/12/21.
After issuance, you have replied by trailing mail.
After issuance of so cause letter, you have replied by trailing mail dated 1/2/22.
This is the 54.
This is the 54.
Oh, this is the only communication.
Yes. And they have also not annexed anything demonstrating that they have replied in a formal way. Let them show. Now, your lordship kindly comes to page 57.
Yes.
Under attached file, this was issued by Bapi Haldar to Indian officials, to Indian oil official. Under attached file is the plot map of Jilli Indian Gramin Vidrak area, which was inquired by IOCL authority. Thereafter, in next page, your lordship will find the sketch map, wherefrom it will appear that they have constructed the go down over 4255. That is middle plot, plot number 3531, that is 4255. RS and LR. The dotted line is the construction area, constructed area.
Right side is the plot number 3534. 3534.
Yes, and thereafter,
in the
horizontally,
left side, the three plots are there.
3530, 3531, and 3532. The middle is 3531, which is
4255.
Yes.
So the construction is upon the total 4 plots.
Yes.
Total plots of 3534 and partial plot numbers of 3 plots.
Yes. Now I will show from the affidavit in reply itself how they have admitted. Reply just once.
Affidavit in reply. Yes.
Affidavit in reply, pay internal page 3.
Yes.
Paragraph 4B.
Yes.
After completion of the project, the concerned office personnel on 11/9/2018 has verified the construction of LPG distributorship center being Jilli Indian Gramin Vitrak and issued a letter that the competent authority has approved the following name and style, namely for LPG distributorship at Jilli, namely Jilli Indian Gramin Vitrak. Now, your lordship, this is completely erroneous. For sanctioning the name of the particular, the person concerned or the official need not visit the site. And 2018, he has not completed the construction. Now, thereafter, the concerned sale officer, in terms of the letter dated 22nd of April 2019 at page 70 of writ petition, informed the Deputy Controller of Explosives that the construction of LPG godown of Jhili Indian Gramin Vitarak has been completed at plot number 3529, 4253, 3531, 4255, subsequently RS plot number 3532 and 4256 under Khutian number such and such. Yes, we admit, we have informed the authority concerned.
The writ petitioner informed the Deputy Chief Controller of the Explosive regarding the construction of LPG godown over the 4 plots. So they informed to the explosive department, not to the oil company.
The concerned sales officer, in terms of the letter dated such of the writ petition, not writ petitioner, my lord.
Yes.
That what I was indicating, one letter was there. Our sales officer indicated 3 plots over which the construction was constructed, informed the explosives authority, you please check this. Nothing, no further indication was there. And I have stated, I will come to affidavit in opposition. But before, whether he has constructed over the same, over the entire, that I am supposed to, whether they have admitted by way of an affidavit that they have considered, constructed. Your Lordship kindly comes to page 5 of the reply.
Yes.
Page 5, the last paragraph F. This is portion of paragraph 4 F at page 5 of the reply.
Yes, proceed.
The petitioner has constructed the godown and showroom apart from the land offered by the petitioner, being plot number 4255 and 4256. Kindly follows apart in RS plot number 3529 and LR plot number 4253. So totaling 4 plots, measuring 0.09 acre, and the necessary conversion has been made, and also LR plot number 4258 has been properly leased by the concerned landowner. Now, by way of an affidavit, he states that 4255 has been converted. Let them place a single paper to show that 4255 has been converted. Till date has not yet been converted. But that's different. The petitioner could not, the next line, the petitioner could not utilize at RS plot number 3531 and LR plot number 4255, as this was not available in the LR records of rights due to the unknown reason of the land department. The petitioner was not at all in fault for not utilizing LR plot number 4255. Now, not utilizing means what? He has stated that he have constructed over 4255. He has utilized the same. His plan says that he has constructed over the same. I will show. Much more clear from page 11, my lord. Of the affidavit in reply.
Yes.
Admittedly, the petitioner was unable to trace the plot number 4255, and due to non-traceable of plot 255, the petitioner has utilized the alternate land, being plot number 4253 and 4258, over which the godown has been constructed as per the sales officer's report. The petitioner has constructed the godown on the land being plot number 4253 along with other land mentioned earlier. it is not a case that he has not utilized the 4255. He has constructed over the same. Just a moment, my lord. In the writ petition itself, he has admitted.
No,
At
is it is a positive fact that he has constructed the go down
Yes.
over.
Now, my
lots
lord,
of-
so the two limbs of my submission. First, without taking any approval, he has constructed. He has misrepresented before the authorities concerned without mentioning 4255. This is absolutely unethical, beyond the rules. Second portion, even if I consider, second thing is that this is not an alternative land. He has unilaterally added some plots, constructed the go down, which cannot be done, has to be placed. That is the procedure. He has to play in any event, whether it is the original land or alternative land. He has to offer. That is the language. He will have to offer and has to be considered by the IOCL. But where is the offer?
No, whether this offer after the writing the number of plot in the application, after the offering the land in the application itself. You understand?
Offer means alternative land.
Yes,
In the-
offer, whether offer of the applicant to the oil company has to be approved by the oil company.
Yes, my lord. That is the language in the.
That one I want to know.
Yes, that is, your lordship kindly comes to the. Otherwise, how can it be?
Yes.
There is an eligibility criteria that the land should be on a plain land without nala, hal, or water body. So that has to be verified. Unless that is done, that I have placed before your lordship at page 26 of my affidavit in opposition.
Basic facilities required for operational LPG distribution. If the offer land by the
land offered by the candidate at the time of field verification meets all specifications laid down in the advertisement on the basis of which LOI has been issued, then the LOI holder can offer, first offer an alternative new land for construction of godown of specified dimensions in the advertised location, which will be considered. So there is a question of offer and consideration. So unless that is done, my lord, how can the construction can be made? I am the authority to adjudge whether this is suitable or not. Suitability of the land. Eligibility, then I will have to come the eligibility conditions touching the land.
Yes.
That shows that are coming, my lord. Very well. Since the question has fallen from your lordship, I will clarify.
Eligibility criteria 8.
Yes, clause 8.
Clause 8.
For godown land, applicant should own a land. This I need not travel into since that is not the, but for academic purpose, I obviously can, since your lordship will be facing several matters of LPG similar nature. Now for this, the next page at page 31, just next paragraph, the land for construction of godown should be plain in one contiguous plot. Kindly see, is one contiguous plot. So he cannot at his own whims add plot.
Yes.
The land for construction of godown should be plain in one contiguous plot, free from live overhead power. Now, who will verify that unless that is placed before me for consideration? power transmission or telephone lines, canals, drainage, nalas should not be passing through the plot. So that has to be verified. That is why the word considered has been issued.
Yes.
Now, if your lordship is still not satisfied that the four plots were not utilized, I will be placing paragraph page 11 of the writ petition itself, which says the concerned respondent has failed to appreciate that in terms of the mail dated 9 December 20, the petitioner offered an alternative land being plot number 4258, apart from plot number 4253, 4255, 4256, on the ground that LR plot number 4255 was missing in the online system. The above mentioned plot number 4258 was subsequently converted. All plots where the godown has been constructed are owned by the petitioner himself. And the same has been recorded in ILA record of rights.
Yes, you have already placed.
Now, your lordship, the first what I have submitted that there was no offer for alternative land. First, he totally misrepresented before the authorities. There was no offer for alternative land. Secondly, the land 4255, which is a godown land, which has been utilized as a construction of the godown, was not converted. Now, I will be placing one unreported judgment of this court. Now, may I place the facts first? No,
yes.
Here also there was no conversion. Your lordship will find from internal page 3. Your lordship can go through the entire judgment, my lord. I'm not. Page 3, second paragraph.
Yes.
It appears from the impugned communication that a discussion was made with the petitioner when he submitted before the company that his prayer for conversion of the land for construction of the godown was under progress and he requested some time from the company. Even after lapse of 2 months' time, there was no positive update from the petitioner. A further later dated search was made for updating the status of commissioning of the distributorship. The petitioner time and again sought for more time for making necessary construction after receipt of the land conversion certificate. So here, construction post land conversion certificate, that cannot be done prior to land conversion, but this has already violated the local laws. So far as Land Reforms Act is concerned, he has to get it converted, classification, thereafter construction. Your lordship knows very well than me. The company invoked the provisions of clauses 5.1, 5.2 and 9.1, which clauses I have placed before your lordship in the LOI. Withdrew the letter of intent in the absence of any progress from the side of the petitioner and the amount of rupees 40,000, which was deposited for FVC. The petitioner submits that he was not in any manner responsible for the delay in conversion of the land in question, which was ultimately received after the letter of intent was withdrawn by the company. From the documents annexed to the writ petition, it does not appear that there is any apparent error on the part of the company in withdrawing the letter of intent. Enough time was granted to the petitioner to commission the distributorship, which the petitioner failed. The petitioner is bound by the terms and conditions mentioned in the letter of intent. In view of the above, the court is not inclined to interfere in this matter. Now, this is one thing. Apart from that, what I indicated at the very first instance, in which cases the court in the writ jurisdiction would interfere in the tender matters. If your lordship desires, I can place those judgments. May I place? Of course, judgments may not need that, so I do not want to make it further lengthy. These are all my submissions, my lord. So far as reply is concerned, let them restrict themselves with the legal aspect of this matter.
Right.
But at factual aspect, since I was not there when they were making the submissions, it will again have to be answered by me.
Come on tomorrow? First matter.
First.
এটা প্রথম ম্যাটার থাকবে, কোনো অর্ডার করছি কন্টিনিউ, ঠিক আছে? এটা রাখুন, এটা সব এটাও রাখুন। Pass over matter. Pass over matter ডাকতে হবে। Pass over matter.
Mister,
Not
make it not today.
Not today.
Mr. Mitra in this matter.
Okay. Very well. Not today. Next.
I am for the petitioner. I am filing my reply to the opposition filed by the private respondent. শুরু করি তারপর বন্ধ করি।
কত? 61.
5 মিনিট আমি শুরু করি, আমাদের ভালো, আমি নিজেই অফ করে দেবো, কোনো টেনশন।
ঠিক আছে।
Your Lordship may, before going to the writ petition, kindly take up the order dated 18th October 2023. The coordinate bench framed the issue. I'm also filing my exception to the report. Order dated 18th of October 2023, passed by the coordinate bench.
Cycle number 62, madam. And while senior advocate Mr. Shoptangshu Basu is appearing for the private respondent number 6. But I'm seeking adjournment on his behalf. He has not come to court.
No, readings have completed, I think.
Absolutely, madam. Make it hard in part and fix any day. Because Your Lordship, on last occasion, I may also place some brief facts. Your Lordship, kindly go through the order dated 18th October
Who is
2023.
appearing for the state?
Shon Sengupta and Amrita Pajamuri, Lordship.
Okay.
Any day subject to Lordship conduct.
Any day, Lordship.
Let it continue in the list. Tomorrow it can be taken up.
Tomorrow, possibly, I have one matter fixed.
But kindly fix it any day in the next week.
Next week?
Next week, Lordship.
And বসে বসে দেখে তো।
27th. An accommodation is short for Ali now. No, haven't. Now? Report to the affidavit in opposition. Reply to the affidavit in opposition filed on behalf of the respondent number 6 is taken on record.
No.
The petitioner also filed exception to the report filed by the respondent number 5. The exception is taken on record.
না হয়েছে সব নিয়ে না, আমার ফাইল নিয়ে।
The matter is otherwise ready for hearing. Next para. An accommodation is sought for on behalf of the private respondent. Accordingly, the matter is urgent today. List the matter on 27.
Hard it part.
Let it be start first.
27th at 2 p.m. my lord.
No, it would appear first up.
At least fairly in the top, otherwise.
Yes. এটা তো এটা under the heading of
within
application.
3 or 5.
দাঁড়াও, তাহলে করে দিলাম। তাহলে প্রথমে লিখো ম্যাটার হার্ড ইন পার্ট কম। as a part and matter.
I'm good, much obliged. I'm good.
ওটা court last এ করবে fix as a part and matter.
একটা অপারেশন দিয়ে নিয়েছিস?
হ্যাঁ স্যার
But copy of the
27 as a part and matter. বুঝছি? কোনটা? প্রথমে হার্ডিন পাঠ করতে হবে, না আর পাঠানো হবে কি করে?
but copy of the reply has been served upon the state.
Yes.
Need not be recorded.
My lord, I am very sorry to mention 61. There is a one application for stay has been filed. Whether matter has been called or not. Tomorrow it will be appear in the list. Can it be before subject to logic? Can it before to be mentioned, my lord? There is some urgency. Application, can it be only on one application is there, my lord?
I do not know whether one application is there or not.
And one application today it is that.
Today I can hear it out, but you have already made submission that
Your lordship,
you think the matter should not be reached.
and yes, on
That's
that
why I understand. It would be appear under the heading of application.
before to be mentioned, I claim subject to your lordship pleasure, my lord.
I have no matter under to be mentioned, I think. Today I have concluded all to be mentioned matter.
Tomorrow some will be listed, by
It will be listed tomorrow under the heading of application, no issue. It will be taken up tomorrow.
before subject to lordship before to be mentioned.
Why?
There is some urgency. Matter is placed after bottom and
It will be taken up in the first half.
It will not be taken by expectation.
It will be taken up in the first half.
Taken up first half, second half.
Not second half.
So many dimension matter. 2 PM matter. It will be taken. If it is taken on the first half, otherwise it will not be taken.
It will be taken up first half.
If the real bottom, it is expected that will not be taken.
কালকে কি আছে? আচ্ছা আচ্ছা তাহলে বিফোর টু মেনশন দিতে দিন অ্যাপ্লিকেশনটা। ওকে ওকে, নো ইস্যু।
Obliged here.
63, I appear on behalf of the petitioner. My lord, it appears, my lord, that if today the affidavit in opposition on behalf had been filed, Lord, I need to peruse the affidavit in opposition. And my lord, if required, my lord, I will file an affidavit in reply because I have not gone through it. Kindly extend the interim order and my lord, fix up any date which suits my lord.
Interim order is till 30th.
30th, yes, because I have what I very
what you want. How many times? 2 weeks.
2 weeks. Yes, yes.
2 weeks. Very good. Please take down. Affidavit in opposition on behalf of the respondent number 1 and 2 is taken on record. Full stop. The petitioner is at leave to file the reply, if any, comma, within 2 weeks from this date. Let the matter appear in the list on 17th of September. Full stop. Next para. The interim order passed by this court on the earlier occasion, which was extended till 30th of August 2024, comma, is further extended till 30th September 2024 or until further order, whichever is added.
আমি এটা কপি
Yes, which for the petitioner?
Lordship, item number 65, I am the petitioner. I am praying 65 now.
'64, you are for the state?
State.
Mr. Agarwal is there? Perhaps some argument was made in this matter? You were there from the argument was there?
Yes, initially one hearing was conducted. Lordship, one day it was heard, partly heard.
Argument heard, judgment reserved. These are the orders.
Reserved for judgment.
Yes.
Then, Lordship, how come the matter has come?
Order of dismissal of the writ application as withdrawn stands. In view of the circumstance, the instant writ petition having been dismissed, there is no scope to passing any further order.
Mr. Agarwal is appearing online.
I am appearing for the petition in the matter, my lord.
Yes, Mr. Agarwal, what is the matter about?
My
It
lord,
was
this is
hard, judgment reserved, again dismissal.
what happened, I tell your lordship, my lord, that this matter was initially dismissed for non-prosecution.
Okay.
But that was not the actually submission made. Then I preferred an appeal against that order. In the appeal, that order was set aside and matter was restored.
Okay.
Then after I moved it before Justice Chaudhary. Justice Chaudhary did not find any order of restoration. So he entirely heard the matter, kept it CAB, but subsequently he found that there is no order. So he remanded, he kept the matter pending. Then, my lord, I again made an application for recalling of that order. That order was recalled and matter was restored. Then after, my lord, this matter is appearing before your lordship, my lord.
Okay.
Actually, Justice Patanayak heard this matter in length, but subsequently we got change of determination. I will have to make submission afresh again, my lord. My lord, kindly fix it at any day.
Okay, come on then September.
Any day, my lord. 4th September, your lordship has passed, kept an order. If my lord approved your lord, if my lord convenient, your lordship may keep it on 4th September.
Okay.
At 2 p.m. My lord, your lordship has already fixed one matter.
Readings have completed, I think. Very well. Please take down. The matter is otherwise ready for hearing. Let the matter be fixed on 4th of September.
At 2 p.m., my lord.
Okay, I have fixed 2 matters at 2 p.m., I think.
No,
4th
no,
of September.
that is on 28th August, my lord. Not
Okay.
on 4th.
Okay, 2 p.m. At 2 p.m.
Deeply obliged. My lord, I beg apology for my lord.
Okay.
Lordship, I am appearing for the petitioner. Lordship, I am appearing for the petition. I am praying for not today as the learned counsel who is leading me in this matter is engaged in another matter in court number 19. For that reason, I am praying for not today.
Where is the reply?
Lordship, I won't be able to reply to your Lordship because I've not been brief in this matter, Lordship.
Who is appearing for the state? Do you know?
No, Lordship. Lordship, I'm not well versed with this brief. For that reason, I won't be able to answer your Lordship.
Not this week.
Grateful, Lordship.
66. For the petitioner.
I appear for the state, my lord.
Main respondent is the West Bengal Essential Supply Corporation. But they affirmed an affidavit and served the copy. The brief facts I am placing before your lordship. The husband of the petitioner, since deceased, was a MR distributor. But at that time, a scheme has been undertaken by the West Bengal Essential Service Corporation that at a subsidized rate, potato shall be sold to the distributor. Potato. At the time of price was very high. And after purchasing the same, they will deliver it to the dealers. Following that said scheme, my lord, I deposited my husband, since this is deposited the money. Page 23, if you want to kindly turn. Page 22. First page 22 is the license, our distributorship license of my deceased husband, Shamsundar Vijay Kumar.
Sanjay sir.
না
কুসুমন সেনগুপ্ত দাঁড়িয়েছিল হ্যাঁ yes সঞ্জয় শাহ দুজনই
This is a license. If you want to kindly turn the page 23.
Yes.
I have deposited the money 5,46,000 West Bengal Essential Supply Corporation on 4th of October 2010 under the said scheme. Then, my lord, delivery order has been issued. If you want to kindly turn to page 24. It's the MR delivery order. Kindly read my lord, first box. Quantity 1400 quintals. Net total potato amount 5,46,000. Total 5,46,000. Then, my lord, figures, everything has been given. After issuance, depositing of the money and issuance of the delivery order, this has been sent my personnel for lifting the potato. But the godown manager told that in the meantime, the price of potato has been enhanced to ₹100 per quintal. And also kindly turn to page 26. Immediately wrote a letter on the very same day addressing the district controller. One document has been handed over to us.
Yes.
But thereafter, what happened, my lord? The husband died. Kindly turn to page 27 on 1st of November 2010. Immediately after death, my lord, the wife, that is the petitioner with your lordship, made a representation to the district controller for returning the money.
Yes.
That is page, my lord, 28. The district controller also wrote a letter to the manager of West Bengal Essential Supply Corporation. Your lordship, kindly turn to page 29. Where for release of the amount deposited for lifting potato soil. Your lordship, kindly turn the first paragraph that Mr. Shamsundar Vijay Kumar, MR distributor of this district, deposited an amount of ₹5 tons so and so for distribution of 14,000 quintal of potato in the PTS according to delivery order bearing number so and so code so and so issued. At the time of lifting, the concerned godown authority advised them to deposit at the rate of 100 per quintal in excess, since the price of potato was increased with effect from 6th October 2010. It may kindly be noted that excess price had not been deposited by the distributor, and potato could not be lifted by the Mr. Shamsundar Vijay Kumar. Have paid for this of his deposited amount on so and so as early as possible. That after another thing is there, then another person. Then kindly come the last paragraph. In view of the above, I would like to request you to kindly make necessary arrangement for clearing their deposited amount at earlier proceeding. Well, in the meantime, petitioner people also got the license, MR distributorship license on compassionate ground at page 30. Then she again made an application, kindly see, page 32. The manager wrote a letter addressing my client on the receipt of the district controller's letter. In response to the prayer of Santo, duly forwarded to the district controller Purulia to clarify that why you have not turned up to accept the potato in spite of the repeated reminder issued by the branch manager Santo. Now this letter has been issued by the manager Potato. Then kindly turn the next page, page 33.
Now, what the letter is?
Letter is saying that we have not went there.
You
for
have not.
lifting the potato.
Okay.
Kindly see last 3 lines. That you have not turned up to accept the potato in spite of repeated reminder issued by the branch manager of so and so. Well, that is not the fact because I have shown to your lordship. Then kindly turn the page. We have given the details that you have never written any letter. Third paragraph, your lordship, come to page 33. But on the plea of change of price of potato, delivery was not given from your end. Since then, no any letter reminder regarding enhancement of price of potato and instruction to deposit any further amount was served upon me. Even no instruction this is from the district controller Pudasat has given to me. We wrote that letter, my lord. Then my lord, kindly come to the next page. Further letter you have given. Then kindly turn to page 35. Again, the district controller requested the West Bengal Essential Supply Corporation to return back the money. You will have to kindly see the first paragraph, kindly refer to the emotional subject. It may kindly be noted that you have requested, I noted so and so, for releasing the amount deposited by 2 emergency orders to Ashutosh Shah and so and so. Second is my client, Mr. Shamsundar Vijay Kumar. Then kindly come to the table. Second, Mr. Shamsundar Vijay Kumar, rupees 5,46,000, DO is from so and so. You are requested to kindly look into the matter and take necessary steps so that they can get back their deposited amount for filing portfolio for lifting portfolio in the swamp. But then, my lord, we have also, HON'BLE, you have been told to hand over the warrant certificate. I have given the same page 36. Warrant certificate of all the legal air, kindly see top 1, 2, 3, 4, 5, 6. That has been handed over to the Essential Supply Corporation. Order is the next page, page 37, by the civil judge. Then the warrant certificate, page 38. And the affidavit, we have also affirmed, page 39. Stating the entire facts, which will appear from page 42nd, third paragraph. Who are the legal heirs? All have signed. Nothing has been happened. But today, Essential Supply Corporation filed an affidavit admitting our position. Told us to kindly take up their opposition. They sought for some documents. Today, nothing remains.
Where is the affidavit?
I have been received.
No, my lord,
I have received the copy.
Essential Corporation filed the affidavit.
They are the only authority.
Essential
I can
Service.
hand over the copy.
They have not filed with this record.
That may happen because matter is appearing after so many times. So one paragraph your lordship made it.
Respondent number 3. Your
And I have
lordship,
given
can
a-
consider the last order dated, my lord, 8th of
Yes, I have given the notice also.
April.
এটা বলছি, 3 জুলাই
No, 8th of April.
না 3 জুলাই 2024 হয়েছে। So now they have accepted the position. Your lordship have fixed the date. Otherwise, in their absence, it will not be better. Some documents have been sought for, but 2 documents we cannot provide. That is the final order. So for the day, lifting, after lifting, my lord, completion certificate. We cannot hand over the completion certificate. All other documents are with us. Because we have not purchased the potato. So question of my lord, completion certificate does not arise. They have sought 4 documents. Original copies with us. Your lordship may dispose of the matter in this line also. I have given notice to Mr. Sanjay Shah representing the corporation. একটা দিন দেখে নিই বড় ভালো সব কথা হয়েছে। There is some link mark, you lordship kindly ignore that.
Original money receipt issued by the account
That is with
division.
us. Then
Copy of
second
work order issued by the
work
Samsung.
order is there. But last two documents.
Completion certificate is issued with a concerned.
It cannot be valid because we have not dictated it.
Completion, how can it be completion?
Yes, and the last one.
The transaction has not been completed.
My lord.
Original challan duly attested by the competent authority, substance delivery of the no delivery has been done.
My lord. So,
As a result,
except those two documents, we are ready to produce the same before the corporation. And a state has nothing to say because they are not involved. They are supporting. District Court wrote 2 letters. And I have also given notice to Mr. Sanjay Shah. The food department is with me. They have given 2 letters requesting the authority because they are the licensing authority. So, my lord, I'm giving to your lordship.
Page number 29 and page number 35.
Right.
Page number 29.
And
Page number 29 and page number 38.
District Court wrote
35.
letter to the corporation
Correspondent
for
number 3.
releasing the money.
Yes, yes.
And this is the,
Today I can be disposed of, but what is the affidavit? I want the affidavit.
that's true, my lord. That's true.
That is the, you serve a notice there.
I have given again, I shall give notice, my lord.
Yes.
And can make it.
Original,
If any day, my lord, it will not take more than 5 days.
original affidavit টা জমা করেন।
I had a talk with Mr. Shah also. And he told me that for those 2 documents, he understood that this cannot be produced.
3, 4, and 5.
Let the corporation file the original document before the
You
court.
are appearing on behalf of the respondent
They are supporting you.
state. Okay. And they are 3, 4, and 5.
My lord.
Answering respondents.
My lord.
I am appearing on behalf of 1, 2, and 6.
1, 2, and 6. Please take down. Matter heard in part. Learned counsel, Mr. Sahara submits that he received one affidavit in opposition on behalf of the answering respondents number 3, 4, and 5. Full stop. It appears that such affidavit is not placed with the record. State respondent number 1, 2, and 6 is represented through learned counsel. Full stop. Next para. It appears that in absence of answering respondent number 3, 4, and 5, the matter cannot be effectively disposed of. Accordingly, the petition is directed to serve notice upon the learned counsel appearing on behalf of the respondent number.
No, Thursday,
3,
Friday, any day,
4,
my
and
lord, it
5.
will not take more than 5 days. Any day at 2 p.m. or subject to
Informing them that matter shall be informing them that the matter shall appear in the list on 2nd of September.
as harding pattern.
Matter heard.
2nd of
As a
September.
pattern matter.
As well. But at 2 p.m. or
No, first.
first, I'll get to it. ওইটা আমাকে দিয়ে দিন আমার কাছে কপিটা নেই মানে I'm taking back this
Yes, yes.
otherwise and I shall hand over a copy to him.
Item number 67, I appear I also appear on behalf of state.
But I think Mr. Shahara will change his position because I am for I am for this petitioner.
For the private response. Would we?
হ্যাঁ করবো and I am also not covered by the issue is covered by judgment of this honorable court where Mr. Shaharai has argued the similar point and succeeded. But here in this instant case, blood the one dealer blood expired and on সবাই appear করছে তো this is the affidavit of service and the only sole point is blood whether the family members of a dead blood ration dealer blood who has been appointed is under obligation to disclose the actual state of affairs and blood file a no objection from the legal years of the other family members or not. But here in the instant case blood, the petitioner before your lordship is the wife, son of the second wife. Lord, according to Lord Mohammedan Succession Act, Lord, all Lord are equal shareholder, but Lord, in this instant case, Lord, while the appointment was considered, at that point of time, Lord, the no objection certificate was taken from these petitioners, and without considering, Lord, the parameters as laid down, Lord, in rules 22 sub rule 6 of the blood control orders, blood, and the appointment was given. Now we have challenged the appointment of the other legal years, and we have raised objection on number of occasions to the competent authority, and that was not adhered. And thereafter, Lord, these petitioners, Lord, has knocked the door of Lord this honorable court under Article 226. Lord, your Lordship would kindly take, Lord, the representation made given by the petitioner. Lord, ব্যাকগ্রাউন্ডটা কোথায় গেল? না, genealogy টেবিলটাতে। Lord, one Abdul Quddus Mondol, Lord, was the person who was appointed as a dealer, and thereafter, Lord, he had two wives. The petitioner, namely Samsun Neha Bibi, the first wife, and Basirun Nesa Bibi, the second wife.
Yes.
I've said it in paragraph 4 of my application, and said Haji Quddus Mondol, who was running the dealership, Lord, died on 30th April 2017, leaving behind, Lord, two wives, 3 daughters, and 2 sons from the first wife, and 1 son, who is the petitioner before your Lordship, and 2 daughters from the second wife.
2 sons of first wife?
Lord, yes. 3 daughters and 2 sons.
2 sons of first wife and 1 son?
1 son and 2 daughters from the second wife.
Of the second wife.
And I've stated in paragraph 5 of my application. Lord.
Yes.
Now, Lord, we came to know that Lord, one Nizam Ali Mondol, the step brother of the petitioner, he intended to, Lord, transfer the said MR dealership in the name of his father, depriving, Lord, these petitioners, and made an application, Lord, in June 25, 2017, Lord, within this stipulated period, Lord, is there 60 days, Lord, and thereafter, Lord, I have annexed the document at annexure P4. However, they have relied on a document which it says the document is, Lord, in my contention, it's a false, fabricated, and engineered, that there is a talaknama. But subsequently, Lord, in my supplementary affidavit, I annexed certain document. And said, Lord, the marriage was subsisting, Lord, accordingly, even if, Lord, there is no, even if, Lord, assuming that there is a talaknama, still, Lord, the right of succession does not go. Because as a son, Lord, of the second wife, the right of succession, Lord, remains. Now, excluding us, Lord, the petitioners and other legal heirs, Lord, a affidavit was filed, and Lord, other documents were supplied to the competent authority, and the competent authority, Lord, has appointed said, Lord, the first said, Lord, Nizam Ali Mondol, Lord, as the dealer.
Okay.
Lord, we have lodged complaints, we have made representations to the competent authority, annexing, Lord, the documents, and your Lordship would get, Lord, the representations, Lord, starting from, Lord, page 31. Now, Lord, one document, Lord, I'd like to show your Lordship, Lord, at page 29, Lord, where there is a legal year certificate, Lord, in Muslim community, Lord, it's called, Lord, Faraznama, though, Lord, it was not, no Faraznama was prepared, but a certificate was issued in favor of
all the heirs,
indicating that all the legal heirs are legally entitled to inherit the property left by the deceased.
Yes.
But despite that, Lord, we raised objection on 26th of June 2017. That was that would be appearing at page 30, annexure P4, indicating regarding the subject was for transfer of ownership, and our objection was given indicating that we are also legal heirs and we have not been indicated anything about it. And thereafter, Lord, we made representation to the district controller also indicating the same thing and reiterating, Lord, these grievances to all other competent authorities. But Lord, all in vain, Lord, nothing could be done. And ultimately, Lord, it was allotted, Lord, to the initially to the first wife, and during the pendency of the petition, Lord, it was transferred to the Nizam Mandal. But initially it was in the name of the first wife. Lord, the deprivation of Lord, the right to success, Lord, has been done at the instance of the private respondent, Lord, in conjunction with the other state respondents. Lord, law is well settled, Lord. As I was indicating, Lord, if I may be allowed to place, Lord, the control order. Lord, hopefully, Mr. Shaharai has supplied a copy of the
whether affidavits, pleadings have completed. Nothing.
The
Pleadings.
First of all, my lord, the license has been granted to the first wife after death of the dealer. Your lordship knows, in case of spouse, NOC is not required. I don't know how this writ is maintainable. Alleged son of the second wife coming before your lordship claiming the license of the first wife.
Shaharai has really buzzed, but I have not concluded yet because I was about to show.
No, just I wanted to know whether
I was just about to show you
pleadings or not, whether
pleadings, Lord, my learned friend has not.
Dismiss for default.
But since it was a dismiss for default, then your lordship, Lord, restored the
State report is
application.
State report is also not there.
The opposition is nothing.
Well, I have to file opposition.
Now, if they want to
opposition or report, everything, anything.
No, because in this case, report affidavit is opposition is required.
Opposition is
dealing all the paragraphs.
That
because the second wife has not come before your lordship. Your lordship knows. We are not admitting that she is the second wife. Even then, the son is coming, challenging the license of the mother has been given on compassionate ground.
What the authority has done, I have to look into.
Your lordship would kindly call for a report and affidavit from the respondent authorities, blood.
You file also affidavits?
But as I said, blood, Mr. Shaharai appeared, blood, in a judgment before the Honorable Division Bench, where really, blood, taking recourse of, blood, the Rule 20 and Rule 6. They have, blood, without mentioning that who are the claimants, but it was decided that the eligible person should give, blood, no objection. That was the issue decided by the Honorable Division. Now, I'll be relying on that later stage of the proceeding.
Yes.
Let the pleadings be completed.
Please check down.
And Lord, I would be seeking, Lord, on the last occasion when your lordship was kind enough to restore the application, I sought for a permission. I sought for a leave to file supplementary affidavit since, Lord, it was pointed out that
let them file the reply. Let them file the report or affidavit.
Lord, otherwise it will be difficult, Lord, with regard to completion of pleadings. Unless I serve, Lord, a supplementary affidavit, again, Lord, it will be lingered. So, Lord, I will be filing a supplementary affidavit within a week. And thereafter, for a deed fee,
your lordship have a look to the order dated, my lord, 20th April 2023. Passed by my lord.
The appeal was preferred. There was a leave. My lord, Mr. Shaharai appeared, and then considering the judgment, observation of this Honorable Division Bench, Lord,
4 years they have come back.
That issue is over.
Without explaining the delay, my lord.
That issue is over. It has been restored. You are not there on the last occasion.
It was restored. So
your lordship was kind enough to restore it.
Okay.
But as I'm suggesting, my lord, first, my lord, the opposition reply. If your lordship found necessary, then, my lord, the supplementary.
No,
because I don't know what type of supplementary they want to
as I said, blood,
it will change the entire nature and character.
Not because the pleadings are there. In support of the pleadings, blood, I will be annexing a document which my learned friend is his defense is that it was Talaknama was pronounced. I want to bring.
I have not opened my case.
No, that is the finding of
How
the.
can I say? What is my point? What is my defense?
Very well. I am passing that. Okay. Please take down.
কাকে দেখাবো?
জানে যার, দেখেছি।
ও পড়ে আসবে না, তার দায়ী আমাদের নেই।
Mr. Shamir Ahmed, learned counsel appearing on behalf of the petitioner submits that the petitioner shall file petitioner petitioner seeking a leave to file supplementary affidavit touching the merit of this matter.
জজকে বলেছি, তুইও বলেছিস, জজ যা বলবে তাই করবে।
It appears that the state authority has not filed any affidavit as well as the private respondent. State authority as well as the private respondent has not filed any affidavit. State authority as well as the private respondent has not filed any affidavit. Considering the situation, for the purpose of effective hearing of this matter, it is required that all the parties shall place their pleadings. Full stop. The petitioner is at liberty to file the supplementary affidavit within a week. Full stop. The supplementary affidavit shall not assess or demonstrate a new fact or extraneous fact to the writ petition.
Grateful Lordship.
Full stop. The state authority is at liberty to file the affidavit in reply against the writ petition within 2 weeks.
After filing the supplementary.
After filing supplementary. Within 2 weeks after filing the supplementary affidavit.
Affidavit in opposition.
Affidavit in opposition. After filing the supplementary affidavit. State.
File the opposition.
Yes.
But can it be 3 weeks, my lord?
After filing supplementary.
Instead of 2 weeks, make it 3 weeks, ma'am.
3 weeks. কি করেছি দেখো?
পারছি না।
Affidavit in opposition. Yes. After the date of filing, 3 weeks. After the date of filing of the report. The private respondent is also liberty. Also liberty to file the affidavit in opposition against the writ petition as well as the supplementary affidavit by the petitioner within 3 weeks. Let the matter appear.
Reply.
Reply if any within a week.
Reply if any by the reply if any by the petitioner within a week. Thereafter. Let the matter appear in the list on 23rd.
Obliged.
Point of militarily left.
September.
Point of militarily left open.
They
Point of
always.
tentatively kept open.
I'm good.
How could a writ petition is not prepared? I have a right to.
Being not a eligible candidate, you have no right.
That's the point
It's
of
the only point.
That point is also decided by Mr. Shahara has a.
They are my client or a family member.
I have got all those judges.
Yes.
My lord, in this matter, I am appearing for the writ petition.
16 minute arm for the respondent oil company written by Mr. Manavinder Singh Yadav, my lord. Let's start, sir.
No. Do you want that I should start? I am ready. If
Yes,
my
yes.
Mr. Yadav is not here, if you.
I will take the note.
Whether Lordship I will be hearing in piecemeal. It's a very big matter. It will take. Let a date be fixed, my lord, so that it can be heard at a time.
No, everything is ready, I think.
Yes, my lord. Pleadings are ready.
You can start today. It will take another 2 days, I think. Long days.
Yes, yes. That's why I'm saying.
Let me just ascertain the matter. What is this?
Fag end of the day, your lordship. Fag end of the day, my lord. Your lordship.
Okay, very well. Very, I'm fixing a specific date.
Yes, madam.
It is your, matter is otherwise ready for hearing. Let the matter fixed on 4th of September. No, 9th of September. 9th of September. Under the heading of hearing.
My lord. At the top, my lord.
Let it,
Top, my lord.
it will be appear on top. Okay.
Number 69, 69.
I am for the respondent, my lord. The matter was on successive occasions adjourned, my lord. As a matter of fact, this has become infructuous. The selection procedure of 2017, and they have filed their affidavit in reply during their 2021. Objection already completed, and the selection of distributorship, the commissioning has already been completed during their 2021. What I find.
The writ petition of 2020.
Yes.
No interim order was there.
Yes, my lord. Commissioning, I have a specific instruction that the location has been commissioned by another applicant, through another applicant, that is Sultana Parveen, on August 2021. As on date, the petitioner was challenging that rejection of his candidature, since he didn't fulfill the eligibility conditions, in as much as necessary documents were not provided, which was required to be provided prior to the date of application, that was not there. Apart from that, he was not the under the OBC category at that relevant point of time, the certificate issued by him, for which his candidature was cancelled, which was challenged before this court. No interim order was passed. Direction for affidavits, and we have filed our affidavit, my lord. Up to your lordship.
It is under OBC category. Advertisement.
Yes, this particular location was under OBC, and the candidate which has been allotted during the 2021 is also OBC.
OBC, but the petition, you say the petitioner is not the.
He didn't fulfill the eligibility conditions in as much as that the certificates which ought to have been issued prior to the date of the last date, which was not there, for which his candidature was cancelled, my lord.
Where is the petitioner? None appears on behalf of the petitioner. On first call. On second call, no accommodation is sought for on behalf of the petitioner. Full stop. Mr. Pushpendu Chakraborty, learned counsel, appears on behalf of the IOCL. Full stop. It appears that the matter is pending since 2020. Affidavit in opposition was filed on behalf of the IOCL. But the matter is not taken up for hearing due to the absence of the petitioner. Considering the circumstances, it appears to me that the petitioner is not at all interested to proceed further with this matter. Thus, the instant writ petition is dismissed for default. Interim order, if any, passed by this court during the pendency of the instant writ petition is also vacated.
Yes.
70. My lord, I am for the petitioner, my lord.
Yes.
My lord, my father was an original EMR dealer. After the death of my father, my elder brother managed the license, and it was a temporary license, but it is running, and he enjoyed the EMR dealership, my lord. I am a younger brother, and I am deprived from the EMR dealership profit, my lord. My lord, yeah, I have there is bread and butter depend on the EMR dealership. I am an unemployed person, but my elder brother deprived me, and without taking no objection from me, my lord. Yeah, they obtained the license as temporary basis, my lord. On the basis, I made a representation before the authority concerned, but authority concerned did not do anything, my lord.
So what is your prayer in the writ petition?
My lord, my prayer is I am praying 50% share of my EMR dealership, my lord. This is the only prayer, my
You have not challenged the order of
Uh,
issuing
uh,
license.
as also as I am challenging the order, challenging.
You have not challenged the order.
Yeah, but my lord, I am praying only my share. So since I am my father was an EMR dealership. This is my only prayer, my lord.
So what authority should do?
My authority did not take any steps, my lord. I made representation before the
Can
authority.
they take steps? Is there any provision to separate the license?
In a separate way of cooperatively, my lord. Jointly, my lord. I am praying jointly. Jointly, EMR dealership would be the
File
joint.
any application for joint license?
Yes, my lord. It is possible, my lord. Otherwise, I shall.
File any application for joint license?
No. I am praying only share, my lord.
The share cannot be given through the control order.
My lord, I and control according to the my lord. According to the.
You have not challenged the
Yes, my lord.
issued in favor of your elder brother.
Yes, my lord. I am challenge. I am challenge. Also challenging my elder brother, sir.
There is no prayer such as.
My lord, according it is a temporary basis, my lord. Kindly.
All licenses are temporary for 1 year.
For the page in the page the 32, my lord. Otherwise, it will be cancelled.
Not made any prayer challenging the license issued in favor of your elder brother.
My lord, according to your dim feet and proper, my lord, as I shall
Where is
state
there
it.
in the writ petition?
He only prayed for the
50%. How can you say that the food and supply department issue?
No, that is not
50%
possible, my
share?
lord. That is not possible.
My lord, can
Asking how can they?
consider the representation
Point of
authority?
time is what
They
the
shall consider.
objections from my
What
learned
they
can-
shall consider. Your
Right,
prayer should be legal. Or
My
according to the
I am unemployed person. I am nothing.
you have to challenge the order of the authority. Order
Yeah.
of giving license. You have not challenged it in this writ petition.
He prayed for proportionment of the shares.
I understand.
The commission.
But whether it is possible?
No. That
The
is
control
not
order.
at all. How
Then
can
you have both the brothers has to be applied jointly.
already
by
license has been
making
granted, my lord.
anything.
His elder brothers. License has been granted.
My lord, kindly consider the representation, my lord.
Only this.
Only this.
Only
After that.
Where is the representation?
My lord.
It's 20, my lord. 20.
Page 21.
29 আর একটা বাংলায় লেখা আছে
नहीं repeat करें.
এই যে page 17 my lord.
Page 17.
Yes my lord.
This is the representation of 2013.
Yeah, yes my lord.
It's a very old one.
Very old representation.
And also I made a demand justice. I submit demand justice. In year 2015. In page number 20.
The license was issued when?
First 1988. After that.
In favor of your brother.
In 1998, my lord, today 2024.
Now, when the license was issued in favor of your elder brother?
It was
95.
2000. It is 2000 up to 1990. 31/1/1990. 19. So first 80. 1980.
License was issued 1988 initially, man.
After
that renewal was given. এরপরে আর কি করবা?
এই তো 1998.
What is the name of your elder brother?
Mahataram.
Sayyid Mahataram Ali.
Yes, my lord.
Sayyid Mahataram Ali was given again issued the duplicate MR license to the said dealer on 31st of August 2008. 2008. Again 2012. This is the only representation?
Yes, my lord.
28/12/2013. What is the license in favor of your father?
Yeah, the father was Izaharul Haq in the year obtained license in the year 1988, my lord.
Where is the license?
License. Previously,
And then after the page 22, my lord.
20?
22, my lord.
23 is the license in favor of the brother. 22.
My lord, RTI applications. The reply of the RTI application. The reference to the so the first time in 1988. Officer code as per the PTS mentioned. So here,
Mahataram
Ali was given the first time in
damage.
For damage on deface reason.
Was again issued on duplicate MR license and they said license 31st January 2008.
So it was not given to your elder brother on compassionate ground.
Previous license being
What does it mean? Damage on deface reason? Incapacitation?
not easily they applied for the compensate appointment. For my statement is concerned and it is elder brother.
Whether the appointment was
Compensate now.
on compassionate ground in favor of the elder brother. Okay, please take down. Kerosene oil license.
Yeah, license obtained, yeah, his elder brother.
Well, license.
No, kerosene and both, my lord. Both, my lord.
MR and SK oil license.
Yes, my lord.
Next 24 why not MR license? Page 24. And 23 is SQL.
Syed Ejarul Haq, comma, father of the petitioner, was MR dealer and kerosene dealer, having MR dealer license number 8 capital NH hyphen Roman 2 hyphen 09364 and kerosene license number 9393 RPH 03.
My lord, I am Mahataram is elder brother, my lord. And Yazarul Haq was their father, my lord.
Yes, I know. And had running the MR shop at Mauja Bara, 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 under PS Noyate district, Nolhati, district Birfu. Full stop. After demise of the said ration dealer, the elder brother of the petitioner, Syed Mahataram Ali, was appointed as a MR dealer and SK oil, kerosene oil dealer, SK oil dealer at the same place. The present petitioner submits that he was totally dependent upon the income of his father, at the upon the income of business of dealership of his father, but depriving the present petitioner, the license was issued in favor of his elder brother, namely Syed Ejarul Haq, no, Syed Mahataram Ali. Full stop. It is the case of the petitioner that it is the further case of the petitioner that several representations were made to the concerned authority, but the authority has not considered the representation. Full stop. Learned counsel appearing, learned counsel, Mr. Chatterjee, appearing on behalf of the state authority, submits that the appointment of MR dealer and SK oil dealership was issued in favor of Syed Mahataram Ali by adopting the formalities under compassionate ground. Full stop. It appears that the next paragraph, it appears that the present petitioner has made representation to the concerned authority, but it was not duly considered. However, if the present petitioner is actually dependent upon the business of the father of the petitioner, namely Syed Azharul Haq, comma, the no objection of the present petitioner is required before issuing of license in favor of Syed Muhtaram Ali, as per the provisions of West Bengal Public Distribution System within bracket Maintenance and Control Order 2030. Under the above observation, under the above observation, the writ petition is disposed of with a direction to the concerned respondent number 4. No, yes, subdivision. No, subdivision 3. Respondent number 3. কি বললাম বল? Concerned respondent number 3 to consider the representation of the petitioner within bracket annexure P3 of the writ petition and dispose of the same after giving a reasonable opportunity of being heard to all the concerned. Full stop. Next para, the to all concerned after giving reasonable opportunity of being heard to all concerned. Full stop. Next para, the respondent authority shall dispose of the representation as early as possible, more preferably within 4 weeks from the date of communication of this order. Full stop. The decision of the respondent authority shall be communicated to the petitioner within 2 weeks thereafter. Full stop. Needless to mention herein that the respondent authority shall dispose of the representation according to the law and the provisions made in WPDS MNC Control Order 2030.
Grateful, my lord. Grateful, my lord.
My lord, next matters, my lord, that no, your lordship, my lord, I won't beseech. I won't beseech your lordship, my lord. But since
We
your
are out
lordship,
of time, Mr.
yes, my
Ahmad.
lord, that's it.
Oh.
Not today, my lord. बैठ गया हम भी थोड़ा सा हम भी सकते